Okay, it's 5:30. We'll get started. Welcome, everybody, to the November 27th, 2023 regular city council meeting. At this point, I'd like to ask the city clerk to please call the roll.
Counselor Long,
Present.
Counselor McLaughlin,
Present.
Counselor Runyon,
Present.
Counselor Randall,
Present.
Counselor Richardson,
Present.
Mayor Mates.
Present. Item 3 is the Pledge of Allegiance. Will everyone please stand and join me in the pledge? I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Item 4 is approval of the agenda. Would anyone like to make a motion to approve the agenda?
Mr. Mayor, I move to approve the agenda.
I'll second that.
It's been moved by Counselor Randall and seconded by Counselor Long to approve the agenda. Is there any discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries. Item 5, we have a presentation from the owners and operators of the Neon Sign Museum, David and Kirsten Benko. Please come forward. We packed the house for you, David.
Thank you for letting us come tonight and just give you an update. It's really important for us to have the city involved with our planning and developments with the Jansen Beach Carousel as we move forward. So we'll just give you a brief update. I wanted to start by restating our mission, just for those of you that aren't familiar. The National Neon Sign Museum is located in the heart of the Dallas Downtown Historic District. The museum captures the history, craftsmanship, and culture that shaped America as seen through the lens of signage and advertising history. Having saved many of America's long-lost icons on display throughout galleries and full-scale authentic storefronts in our ballroom, our mission is to continue our passion of restoring lost arts through the Jansen Beach Carousel, leaving a legacy for the future generations that travel to the beautiful The Dalles. So in the spring of 2023, some of you know that we were made aware again that Restore Oregon was still looking for a home for the Jansen Beach Carousel. And we decided that we would move forward with putting in a proposal for the carousel. And then in September, it was announced that we would be the recipients in the Dalles of the carousel. So we are very excited about this opportunity. The carousel is a C.W. Parker. It came to Oregon in 2028, and so in 1928, and so in 2028 that will be its 100-year anniversary in the state of Oregon. So our mission and goal with the restoration is that we would actually have it operational by 2028, which is 5 years from now. So we've had a lot of local support, which we are very happy about. And our goal is to continue to preserve and restore this history that really includes the dying arts that go along with the carousel, the craftsmanship that went into this time period. So as far as education and public access is concerned, we sort of have 4 points to go along with the carousel as we are moving forward with it. And we hope that these start right away as we start the restoration of the horses. So number 1, the exhibit will prove to be one of the primary affordances in providing public access, allowing the ability for historic demonstrations, guided docent tours, and special presentation events. As soon as we can start restoring the horses, either some of those demonstrations will be in the ballroom, and once the educational center is completed downstairs in the museum, those will take place downstairs, but that alone will begin to draw tourism into the Dalles. The second piece of this that will also start fairly immediately is a STEM-based program. So as you guys know, all of the STEM-based programs start with working with our hands, and this is going to be a great opportunity for the youth and college students to get involved and come down and work with craftsmen from the industry. The third one is goes along with number 2, which is really partnering up with the local college and the colleges in Portland as well and the local area. And then lastly, our point number 4 is that this venture really is just about continuing to showcase history in a very vibrant way. Next is restoration and maintenance. Just to give you sort of a big overview picture, from Restore Oregon, the seed money that we really need to kickstart this is $250,000. That would cover architects, planning, development, hiring an administrator and a grant writer. That's for 2023. That's really our primary goal right now, is we're working on grant opportunities to secure those funds either locally or through other tourism grants that are available. And as we progress from 2024 all the way over to 2026, most of that funding comes in different phases. If you go to the next slide, 2025, that's the initial groundbreaking for $4 million in 2026. There's $2.5 million that are allocated for the structural needs of the carousel and to fully reconstruct the actual structure of the pavilion, not the pavilion, but the operational construction. And then in 2028, that is when we would actually begin to assemble the carousel on site. As far as the fundraising goes, really, it includes not only just the restoration of the horses, but it also includes preparing for the long-term maintenance of the carousel. So sustainability and long-term impact. We've participated with our community over the last few years of not only restoring the Elks Lodge, but helping with the outdoor walking tour and museum, the signs that are outdoor on display, and we continue to add more to those. And the Northwest Mural Fest, which many people were involved with over the last couple of years. And if you're not aware, Lizzie Keenan, she works for Mount Hood Columbia River Gorge Regional Tourism. And one of the focuses of Travel Oregon and the Tourism Alliance is Wasco County and bringing tourism to this actual area of the gorge. So she's very excited to be working with us. Then to move forward to technology and how we hope to sort of advance this through our galleries and just around the community, both inside and outside of the museum. For the carousel, as far as using technology, one thing we talked about with Restore Oregon was installing the UV heating throughout the building. And we will be seeking more expert advice on that as we move forward with the developments. So that's sort of an internal preservation concept. And then next is the NFC digitization, which we will be using TAP Network, and that will allow people to be able to visually connect with the restoration process, whether they're actually at the facility or they're away from the facility. All they need is the app to be able to continue being educated about what is happening and the restoration process. And then lastly is the tactile display miniatures. We would like to move forward with a plan as we begin developing to create miniatures of the carousel, and some of those do exist, that would help our visual impaired community. Then on the partnership and collaborations, there's several different institutions that are now interested. Smithsonian, we've had an ongoing relationship with them over the last few years. Simon interned with them for several months, and they've been interested in working on a project with us. And it's possible that this might be something that they would like to showcase and partner with both Smithsonian and us. There's also Columbia Sportswear and Nike, who could be pursued for not only the grants, but also just for support locally. And recently Janssen was bought out Perry Ellis and brought back the Janssen swimwear line. So we plan to do some fashion shows and networking with them to also bring more tourism and events to the Dalles. So donor recognition and stewardship. A number of people have asked us what sort of naming opportunities exist. There's the Name a Horse campaign, which is $25,000 to name a horse. That also goes towards the ongoing restoration and maintenance of the actual carousel. Of course, there's the ongoing educational wing, library, research, archives, neon workshop, and ballroom. All of those still have naming opportunities. And finally, as you'll see in this picture, we still plan to continue a relationship with Restore Oregon. We have hours dedicated that they're going to be mentoring us through the next phase 1 of moving forward with grants and securing funding and being prepared to actually start the physical restoration with some of the craftsmen that we've met locally and painters that we've met locally. And that is our hope, is that we start local and move out, similar to Northwest Mural Fest, assembling a team of artists and craftsmen. So currently where we stand with taking the reins together is that we are looking for immediate financial support to facilitate our current phase 1 initiatives of the $250,000. And also teaming up is necessary to be in a timely manner, since we are looking to assemble our steering committee for each of the different sectors that need to be developed. So that is our short, brief overview.
Any questions for the Benkos?
This is really exciting.
Maybe you could explain a little more about the Restore Oregon didn't just hand the carousel to the Neon Museum. There was a competition. Maybe you could elaborate on that.
Right. So Restore Oregon in 2012 received the carousel and were responsible for saving it from being scrapped, more or less. And through that, they started seeking a plan to restore the carousel and the horses and what would be best practice. That was their role. And their secondary role was to find someone who could steward forward the actual operational aspects and bringing the carousel back to life in a city. Their hope was that it would be Oregon, and a number of cities applied for it. And we'd heard about it, and it was kind of during the COVID phase. And at that time, we didn't move forward. And then somebody brought it to our attention again and said, this is really interesting. And we thought, you know what, this actually would one foot in front of the other, and began the process of going in and out of businesses and touring and just seeing what the feeling was in the Dalles and would this be an appropriate city. And finally, we went and met with them along with the team from the city and our board of directors and our advisory committee. And that was several more interviews. And then in September, about 2 weeks before we had the announcement, they let us know that we had moved up from, I don't know how many they started with. It was quite a number, but we went from 100 to 50 to so many to 4, and then the final announcement.
Safe to continue with. Okay, item 6 is audience participation. During this portion of the meeting, anyone may speak on any subject which does not later appear on the agenda. Up to 3 minutes per person will be allowed. Citizens are encouraged to ask questions with the understanding that the city can either answer the question tonight or refer that question to the appropriate staff member, who will get back to you within a reasonable amount of time. If a response by the city is requested, the speaker will be referred to the city manager for further action. The issue may appear on the future meeting agenda for city council consideration. Is there anyone in the audience who would like to address the city council for up to 3 minutes on any item that is not on the agenda? Okay, last call. Okay, thank you. Item 7 is the city manager's report. Mr. Klebs.
Thank you, Mr. Mayor. Just a couple quick items. I wanted to let the council know that I attended Mid-Columbia's annual Housing Stabilization Summit a couple weeks ago, held in Hood River. We also had a facilitated city council goal setting, as you know. We've received some of the preliminary draft minutes from that session that we'll be reviewing with our leadership team tomorrow. And we'll likely see the more full report come back before city council for consideration in early January. I had an excellent touch base meeting with the Dalles Main Street, who seems to be gathering some additional momentum and working on downtown revitalization, and a similar productive meeting with the Dalles Art Center as well. I had the pleasure last week of attending some of the muster meetings that the City of the Dalles Public Works has. with our water, wastewater treatment plant, wastewater and street divisions. So it was really good to touch base with them and see how things are progressing. And in a similar vein, I had a ride along with our code enforcement officer, which was also very enlightening to, really see the daily work that they interact with and the challenges and opportunities that are in front of them. And with that, that's my report.
Thank you. City Council reports. We'll start on my left with Councilor Runyon.
Just a few things. Wasco County Pioneer Association, I attended that as they prepare for their May annual event, and the council goal setting retreat up at Columbia Gorge Community College. And also I was invited to and went to a state attorney general candidate welcoming to the Dalles running for office. And that was interesting, and hope to see the rest of them.
Thank you. Councilor Richardson.
Thank you, Mayor Mays. Briefly, in the last few weeks, we've had goal setting, the city council and staff goal setting session, which I thought was very productive. And I'm glad that we're doing that ahead of the budget process so that we can have that conversation in a sort of careful and thoughtful manner. There was a traffic safety committee meeting. I'm assigned to that. Good work ongoing. And I also attended the Housing Stabilization Summit where I saw you and a number of others. Thanks.
Councilor Randall.
Thank you, Mayor Mays. Just a couple items. On the 17th, I also attended the goal setting session. And on the 24th, attended the Starlight Parade with yourself and Councilor McLaughlin. And that's it.
Councilor Long.
So like everyone else, I attended the council goal setting meeting, and that's what I accomplished in the last 2 weeks.
Councilor McLaughlin.
I attended the goal setting as well and an airport commission meeting, and I participated along with Mayor Mays and Councilor Randall during the Starlight Parade.
In the interest of time, I'll forego my report and save up for next month. Okay, consent agenda is number 9. Items of a routine and non-controversial nature are placed on the consent agenda to allow the city council to spend its time and energy on the more important items and issues. Any councilor may request an item be pulled from the consent agenda and be considered separately. Items pulled from the consent agenda will be placed on the agenda at the end of the action items section. Tonight, we have just one item on the consent agenda, and that is the approval of the November 13th city council meeting minutes. Is there a motion to approve the consent agenda?
Mr. Mayor, I'll move to approve the consent agenda.
And I'll second that.
It's been moved by Councilor Long and seconded by Councilor McLaughlin to approve the consent agenda. Is there any discussion? All those in favor, please say aye.
Aye.
Opposed, motion carries. Item 10A. This is an appeal of a plan commission resolution denying an appeal of the community development director's decision, denying a sign permit to J.R. Zukin Corporation, DBA Meadow Outdoor Advertising. Now is the time specified for the city council to conduct a quasi-judicial public hearing to consider the following matter. Appeal application number 35-23, an appeal of Plan Commission Resolution number PC 618A-23, a resolution denying appeal application number 33-23, which appealed the Community Development Director's February 27th, 2023 denial of sign permit number 2589-23, submitted by J.R. Zukin Corporation, DBA Meadow Outdoor Advertising, and requesting to replace an existing off-premise advertising sign, i.e. a billboard, located adjacent to a city street with a larger billboard. As a threshold matter, the 2020 City Council rules limit quasi-judicial public hearings involving an appeal of the Plan Commission decision to 1 hour and 15 minutes per hearing. The purpose of that rule is explained as to ensure sufficient time exists between public hearings and other scheduled items so the public is not kept waiting unduly for other City Council business on the agenda. However, the City Council rules also allow the City Council to extend that time if the matter is of complex nature or requires extensive testimony. Absent objections from any city councilors, I am recommending that the City Council waive the 1 hour and 15 minute time limit and proceed with an an aim or a goal to reach a decision here within 2 hours instead. Does any city councilor object to waiving that 1 hour and 15 minutes? Okay. We will proceed then, hearing no objections. Quasi judicial hearings require the city council to make decisions using a certain process comprising criteria, evidence, and specific findings. The substantive criteria upon which the city council will base its decision in this matter are found in the Dalles Municipal Code, Title 10, entitled Land Use and Development, Section 10.3.020.070, entitled Public Hearings, Section 10.3.020.080, entitled Appeal Procedures, Chapter 10.6, entitled General Regulations, Article 6.070, entitled Measurements, Chapter 10.13, Sign Regulations, Article 13.020, entitled General Provisions and Procedures, and Article 13.050.150, entitled Off-Premises Advertising Signs. A public hearing is required by Oregon law, and certain rules apply. First and foremost, you must be recognized by me in order to speak and present testimony. When you are recognized by me, please proceed to the microphone and state your name and mailing address for the record, both of which are required by Oregon law. The hearing is also required by law to be recorded. Prior to the public hearing, a determination will be made of the counselor's qualifications and allow for challenges from the audience. Then I will open the public hearing, and the public hearing will proceed as follows. I will open the public hearing with a staff report. The purpose of the staff report is to further identify the applicable criteria of the case being considered and to provide background information about the case. The staff report will be presented by Joshua Chandler, our Community Development Director. We also have Jonathan Kara, the City Attorney. We also have Matthew Klebs, our City Manager, and Chris Crean, who is our Special Counsel. After the staff report, we will hear the appellant's testimony and presentation. Next, I will ask for testimony from any proponents. That is, those that are in favor of the application or in favor of the appeal. As with our normal public process, a 3-minute time limit will be installed. Please be brief and succinct and avoid repetition. Do we have a list of? We don't have a list? Okay. There is nothing wrong with simply saying, I agree with Meadow Outdoors appeal, or you can say, I agree with the arguments of the appellant's representatives. You can be that short and succinct if you wish. After that, I will ask for testimony from any opponents, those not in favor of the application. Finally, I will ask for testimony from anyone else who wishes to offer testimony or ask questions. If any opponent testimony is submitted and to honor the right of rebuttal, I will then provide an opportunity to hear again from those in favor of the application. To expedite the hearing, counselors may ask questions of persons as they testify. This includes the city staff and the appellant and anyone who testifies. As with the presiding officer, I will begin with questions of the staff and the appellant, and then defer to the city council, starting on my right with Councilor President Tim McLaughlin, and proceed from right to left. Questions can take place during the public hearing or after the public hearing during council deliberations. City council members may have the option of taking their turn or passing and asking questions later on, or deferring to another council member. When the process has been concluded, I will close the public hearing and the council will deliberate towards a decision. During the hearing, some important standards apply. Number one, first, those who testify must hold their testimony to the decision criteria. As in all land use hearings, there are a complete set of rules, procedures, and criteria that we must follow. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford counselors and the parties an opportunity to respond to that issue precludes an appeal to the Land Use Board of Appeals based on that issue. Third, an appellant's failure to raise constitutional or other issues relating to proposed conditions of approval with detail specific enough to allow the city to respond to the issue precludes an action for damages in circuit court. And fourth, and subject to the provisions of ORS 197.7976, Prior to the conclusion of the public hearing, any participant may request an opportunity to present additional evidence, arguments, or testimony regarding the application. If such a request is made, the law states the council must grant the request by either continuing the hearing to a time and date at least 7 days from the date of the initial hearing, or the record must be kept open for a period of at least 7 days. These are the rules. Are there any questions? Okay. Now, I have some questions that I have to ask the city council. Have any members of the city council had any ex parte contacts, conflicts of interest, or bias which would prevent you from rendering an impartial decision on this matter? I'm going to be asking each counselor individually. We'll start on my left with Councilor Runyon.
No, although, a small town, been in business for 25, 30 years. It's hard not to know somebody from every business or political entity over that time, but I've not discussed any of this with them at all throughout the community. Nobody at all.
Thank you. Councilor Richardson.
No.
Councilor Randall.
No, other than to say I've overheard a few brief conversations among coworkers, nothing that would significantly impact my objectivity.
Okay. Councilor Long.
No, I haven't discussed it with anyone.
Councilor McLaughlin.
I have been contacted by many people in our community since I have lived in the Dalles for 50 years. And I must say that I have a longstanding relationship with the owners and management of Meadow Outdoor Advertisement. I contacted the Oregon Board of Ethics to determine if a conflict of interest existed. I have no financial ties to Meadow. They reported no, that I don't. I also conferred with our city council legal department, and he concurred. Since I've been around town, a lot of people talk to me, and I have a list of people that came to me, but my response was, I simply, I'm not at liberty to discuss. So that's what I did. Jim Wilcox, Bill Hamilton, 4 constituents at the local grocery store, 36 letters in my packet. Mayor Mays and I talked procedural questions. Rod Runyon and I talked procedurals. I had 6 letters via city email account. I was repairing the microphone cord at Spookies prior to the start of the meeting. Mr. Zupikin came up to me, but we just had a friendly conversation, but it wasn't about the content. And I departed before he spoke. At Lions Club, Chris was appealing to members for support. I stepped out of the room during his talk. I feel I can make an unbiased decision with the interest of our city and the facts of the case.
As far as I'm concerned, I did have a short conversation also with Mr. Wilcox on November 14th at Spookies. It was very short, and Mr. Wilcox understood that I couldn't discuss the item any further. On November 20th, I was shown a handout that was apparently mailed or given to the Civic Auditorium Board of Directors. I did not read it, but it was obvious that it was an appeal to the Civic Board to support the appeal. On November 22nd and 26th, I had discussions with Councilor McLaughlin about procedural matters regarding this public hearing. With that, does anyone in the audience wish to challenge the qualifications of any members of the City Council? Okay. Now, one of the things I think I'd like to clear up before we start the public hearing is some terminology. Some of it has been a little inconsistent as I look through the 600-page packet. I think we have to understand the difference between a linear mile and a road mile. A linear mile is 8 billboards within a circle that has a 1 mile radius from the subject billboard. That is the staff's position. That is called a linear mile. And on the other side of the coin, we have a road mile, which this is at the crux of this appeal. And a road mile is 8 billboards within a 1 mile section of roadway, which is the appellant's position. Just want to make sure the terminology is consistent throughout. I'm opening the public hearing. And can we have the staff report, please?
Yeah, good evening. Amy, can you unlock my shared screen, please?
Josh, you might want to check your mic also.
Test. Like it's good. Great, thank you. Yep, that works. Good evening, Mayor Mays, councilors, Joshua Chandler, Community Development Department. As mentioned, in the essence of time, I'm going to try to breeze through this presentation, try to hold questions till the end. What's in front of us is appeal number 035-23. The appellant is JR Zukin Corp. doing business as Meadow Outdoor Advertising. The address is 747 West 2nd Street, not East 2nd Street, which was listed on pages 1 and 6 of my staff report. My apologies for any confusion. Zoning district is general commercial. And as mentioned, Mayor Mace has mentioned this, this is the appeal of Planning Commission's resolution number PC 618A-23, which denied appeal number 033-23, the community development director's denial of sign permit number 2589-23 to replace an existing off-premises advertising sign located adjacent to a city street with a larger billboard. As of today, 36 comments were received in support of the appeal request. Project timeline: the original sign permit was denied on February 27th. The appeal number 033-23 was heard in front of the Planning Commission September 7th and October 19th. The appeal was denied October 19th. This appeal in front of you, 035-23. City Council is tonight, November 27th. And as a reminder, the 120-day timeline for this application is December 2nd, this Saturday. This is a map of where the billboard in question is located, right across the street from Thompson Park, West 2nd Street. This is the billboard in question. The existing billboard has a sign face of dimension of 8 foot by 16 feet. The proposed billboard is an enlargement to 8 feet by 24 feet. So the permit requirement, the reason we are here with the reason a permit was required is the section of our code that touches on, although this section touches on the fact that routine maintenance does not require a permit. Any structural alteration to an existing sign does require a permit. And as mentioned, the request is to enlarge an existing sign. Therefore, a new sign permit is required. So the interpretation at issue is this: Dallas Municipal Code 1013-50-150 C2, city streets. The maximum number of advertising signs shall not exceed 8 per mile, with no more than 5 on one side of the street and no closer than 300 feet apart when measured at right angles to the street center line to which the sign is oriented. But this is really the part of the sentence that we will dive into tonight. Staff's interpretation, as Mayor Mays mentioned, is a linear or radial mile measurement. The appellant's is a road or street mile. This has been consistent with the appellant since at least 1992. So terminology, I think we can glaze over this. As Mayor Mays mentioned, there's been some inconsistency of terminology used throughout. However, both staff and the appellant have had consistent positions on interpretation. Staff's interpretation is as the crow flies. And so if you start from a center point, you measure out in all directions, center of a circle, and that gives you a radial mile. So those two can be used simultaneously. The appellant's interpretation is a road or street mile, and that is as the road curves. And a linear mile is not a road mile. So the basis for denial, this is the linear or radial mile interpretation. This is a sign that this is the map that staff generated. This shows the number of billboards within 1 mile of the subject billboard, which is the red dot. As you can see, there are 24 billboards total within 1 mile of that location. Over 14 of those are non-highway billboards. So we only looked at the fact that there's 14 in the area. So to provide a bit of a graphic here, this is a line stretched across from one side to from one point of the subject billboard. As you can see, use a line, it goes around continuously, and that's how you get your radial measurement. Staff also created a map regarding the appellant's road mile interpretation. This map was generated using GIS, and it was designed to not allow no more than 8 signs per road mile on all roadways in the urban growth boundary. This has been the appellant's interpretation. Therefore, a sign was placed on every single street in the zone that they would be allowed. Therefore, in looking at this, as you can see, over about 170 billboards could technically be placed with this interpretation. And this does not take into account any roadways that have split zoning. So for instance, if you have a roadway that has one zone on one side, one zone on the other, staff removed all of those. It does not take into account ODOT requirements or any business plans of any business that is choosing to place any signs. So in filing the appeal, staff corresponded with the appellant multiple times over this last year regarding this interpretation. The appellant notified staff of their intent to appeal in June. And looking through our code, staff determined multiple procedural inconsistencies with the Dallas Municipal Code, specifically 1013, which mentions the ability to appeal, but then 10.3 specifically says that a ministerial application's decision is the city's final decision. So therefore, inconsistencies in the code. However, staff decided to err on the side most beneficial to the appellant and allowed the appeal to move forward. Rather than an appeal, staff offered the appellant a collaborative alternative. This is included as attachment 9, pages 72 to 73. There's 2 options: move forward with the appeal or collaborate with staff on amending these inconsistencies with chapter 1013. This compromise would allow both the city and the appellant to marshal their resources on a comprehensive sign code with the tentative plan to have an initial discussion at Planning Commission in autumn 2023. Of course, we've now passed that. Alternatively, once the appeal is filed, the city is instead required to focus efforts and expend their resources on defending the appeal. This further prolongs the ability to address the inconsistencies in our code, and it leaves the city open to future litigation. The appellant provided no response to this collaborative alternative, but rather submitted a notice of appeal about 3 weeks later. This notice of appeal was submitted about 18 weeks after the original sign permit was denied. So within the appeal 035-23, the appellant's 4 reasons the city council should grant the appeal request. These have been reordered for purposes of this presentation. Staff will address the issues raised in this appeal regarding applicable criteria to the code. But we've also included responses to the appellant's reasonings. The first, the lineal mile measurement benefits the city's economy, thus fulfilling policies set forth at the comprehensive plan. This is not a criterion used to determine compliance with the Dallas Municipal Code. The appellant does not explain why economic impact is relevant to the appeal, and the staff does not believe it is. Aspirational statements in the comp plan about encouraging economic activity are far too general and broad to apply to an individual sign permit application. Nothing in the provided statements about economic vitality in the comprehensive plan shed any light on the interpretation in question. The next reason, since 1974, the city has, as a matter of course, approved placement of billboards based on a lineal mile measurement. Once again, this is not criterion used to determine compliance with the Dallas Municipal Code. Determinations are based on regulations within the code, not perceived historical precedents. However, staff did consider past procedures when making their interpretation. Staff was, jumping ahead here, staff was unable to find and the appellant unable to provide information justifying any historical precedents or overall consistency of city billboard review. The point tonight is to determine the intent of the city council when the sign code was adopted in 1992. Here, staff has provided sign ordinance language January 1974 to September 1992, as well as September 1992 to present. The areas in bold are the areas that the sections that have changed. So as you can see, this section of the code has almost been unchanged since 1974. One of the biggest changes in 1992 was the addition of a city street requirement for placement of billboards, and that's what's being appealed today. Looking at the adoption, the process for adopting that sign ordinance, the appellant was a vocal contributor during multiple sign code work sessions in 91 and 92. In 92, the appellant requested the addition of a road mile into the sign ordinance. You can see a letter from their attorney, attachment number 2. However, upon adoption, the road mile was not added into the sign ordinance, and the existing language has remained unchanged since 1992. As you can see from this, it's clear that City Council's intent was to not have the road mile mentioned as a form of measurement within a billboard, within the sign ordinance. So historical permit review, the appellant argues since 1974, the city as a matter of course approved placement of billboards based on a lineal mile measurement. However, staff confirmed only 3 of the 42 billboard locations citywide have permits mentioning anything to do with 8 per mile. This includes all billboard permit records available and almost 300 pages of your packet this evening. So in diving into the research, staff also took a look at zoning and how other sections of the sign code have changed. The January 1974 to May 1984, the text, advertising signs shall be located in commercial or industrial zones, kind of vague, basic. But in 1984, there was a change that advertising signs shall be located only in the general commercial and industrial zones. However, since 1998, 13 billboards received city zoning approval in non-permitted zoning districts. So therefore, this is another example of the inconsistency of billboard permit review over the years. This is a current billboard inventory, the city of the Dalles. Everything in green is a billboard that's located within a permitted zoning district. Everything in red is in a non-permitted zoning district. 42 billboards total. 14 of those are permitted correctly. 28 are in zones that are not permitted in are in non-permitted zoning districts. As a reminder, 13 of those were approved since 1998. So looking at the last 2 reasons, staff will address these 2 reasons. Final 2 arguments are criteria that we addressed in the staff report. Looking in your staff report, land use applications in front of Planning Commission, we look at the criteria that is met in the municipal code when reviewing an application. Within this staff report, you'll see criterion met with conditions, criterion that's not met, criterion that is not applicable. I'm only going to be addressing the criterion that's not met and criterion that is not applicable in this presentation. So looking at this first, nothing in the text of the Dalles Municipal Code 1013-050-150 C2 limits the number of billboards to 8 per radial mile. Finding 13B in your staff report, this is, as mentioned, the interpretation at issue. And really, when you look at this sentence, there's 3 requirements for sign placement. The one that we'll be discussing is that signs shall not exceed 8 per mile. We didn't cover 2 or 3. Those were not reviewed because 1 was not met. So therefore, we didn't move on to review the others. So When reviewing all land use applications for setbacks, distances, height, average slope, density, rounding, staff uses the provision in front of you for measuring distance. Distances are measured horizontally. When determining distance for setbacks and structural dimensions, all distances are measured along a horizontal plane. And it's like the picture that's provided to you in the municipal code. I provided these squiggly lines. They may look a little silly, but they're here to resemble that. These lines are shown to demonstrate that measuring along a curved distance or measuring along an elevation change does not comply with this code provision, nor could they be classified as the squiggly or the one on the left above, nor could those be classified as linear. The last part of this section is that distances are not measured by following the topography of the land. So topography is not a definition that's specifically listed in the Dallas Municipal Code. And when definitions are not listed in the code, they have their commonly accepted dictionary meanings. Any basic Google search will most likely bring these three up. These were the top three that I could find. And all three of these have things in common: artificial and man-made features. So I'm looking at that. Roads and streets are not factors in determining distance. Thus, a road mile interpretation is incorrect. And then the last reason the appellant believes that the city council should grant the appeal request is that it will render existing billboards non-conforming, thus consigning them to eventual demolition. This slide is the slide in the Dallas Municipal Code referencing non-conforming signs. And signs that, to be a non-conforming sign, they do not conform to the provisions of this chapter, and they lawfully existed and were maintained on the effective date of Ordinance 92-1153. The subject billboard was constructed in 2003, which is 11 years after Ordinance 92-1153. Therefore, per the Dallas Municipal Code, that billboard is not and can never be a non-conforming sign. So the appellant argues that this interpretation will consign all of their signs to demolition by classifying them as non-conforming. As a reminder, that is not correct. And with that, staff has provided the recommendation in front of you. Additional alternatives have been provided. And staff is urging the city council deny this request for an appeal. And I can keep this slide up for you, or I can bring it back up when we get to making the motion. And then with that, I'm more than happy to answer any questions.
Okay, as I said, I'll start with the questions and then we'll go from right to left with Council President McLaughlin. Could you put those 4 points up there again, please?
Oh, yeah.
Okay, regarding number one, nothing in the text of the code limits the number of billboards to 8 per radial mile. Did I understand you to say that, will you agree with that statement? It's not applicable? Did I understand that correctly?
No, this is one that the criterion was not met. Nothing. Yeah.
Okay. Number two says, since 1974, the city has, a matter of course, approved placement of billboards based on a linear mile. That it really should be a road mile, shouldn't it? I think the applicant, the appellant, that's one of those confusions that I was mentioning before. So instead of saying linear mile, he really meant road mile. Or
correct.
Right. Okay. Did I hear you say that there has been no evidence presented that would lead someone to believe that since 1974 that they've applied the linear or the road mile criteria?
Correct. Only 3 of the 42 locations had have permits that mention anything about a road mile.
Okay, of the other 39, were there any mention of radial or linear mile?
There were not.
Okay, on the issue of the non-conforming, I want to make sure this is clear because this was littered throughout the 600-page packet about this non-conforming issue. You're saying that this sign, this particular billboard, would not be a non-conforming sign.
It couldn't be classified as non-conforming per the
Okay.
Dallas Municipal Code.
And the rest of the signs within the 1 mile radius, none of those would be considered non-conforming.
You would have to take a look at the year that they were constructed.
So it depends.
Thank you, Chair.
Sure.
Mayor Mays, to Chris Crane, your special outside counsel. The other thing about a non-conforming use, it has to be a use that's not allowed in the zone, say a grocery store in a residential neighborhood, right? Most of these there was a map that we saw that showed where billboards are allowed. So as long as the billboards or signs of this nature are allowed in the zone, it's not a non-conforming use. And it's my understanding this billboard is in an area where the signs are allowed. So it's not a non-conforming use because billboards are allowed in the zone. You just can't issue permits for more signs because you're already at the 8 mile cap, 8 per mile.
Are any of the signs within the 1 mile radius in zones that shouldn't have been approved in the first place because they're in the wrong zone?
In this 1 mile radius?
Yes.
There are a few, yes.
Okay. And
so they may be non-conforming with or without this discussion, frankly.
Okay. So those could be non-conforming.
Correct, but it's
Okay.
not a determination, not coming from the determination this evening.
Okay. The last paragraph of your, page 10. Last paragraph. The appellant notified the staff that it disagreed with their interpretation of they applied in October of 2022 for a sign permit. And you let them know that the rule is going to be a linear mile criteria.
Correct.
Okay. So they objected, told you they didn't interpret it that way, right? But
Correct.
there was no other, they dropped it. They dropped the request for a permit.
Well, the one in that paragraph, the titled interpretation at issue, this one was actually, they had applied for one that the city wouldn't be approving, not only for this distance measurement, but because it was placed
Right.
too close to the right of way and within an area of our infrastructure.
I'm sure they weren't concerned about the last part of that, but when you said that it didn't comply with the radial mile or the linear mile, they just dropped it.
Yeah, no permit was actually submitted on that one.
Okay. On page 11 at the top, you talk about an application that, or at least a request or an inquiry made by another, was this another billboard company, not Meadow Outdoor?
It was not, it was just a private property owner that wanted to put up a billboard.
Okay, and then you told them about the radial mile or linear mile
Correct.
criteria. And did they express a problem with your interpretation at that point, or did they just drop it?
They dropped it. I think the response was "C'est la vie."
Okay, was this the first time that someone had applied for a billboard permit since you were hired as Director of Community Development?
I believe so.
In the fourth paragraph, you talk about you mentioned before about the minutes from February 1992, where the Plan Commission considered the sign code for adoption. You see the paragraph I'm talking about?
Yep.
Okay. It starts with on June 13th, 2023. At that time, the appellant's legal counsel, which I believe was Mr. Jim Foster, is that right?
Correct.
requested the Plan Commission specify the measuring distance between signs along the road mile. The Plan Commission did not include the appellant's legal counsel's recommended clarifying language and instead recommended the code's current language for the council's adoption. So would you acknowledge that despite the Plan Commission's rejection or lack of response to Mr. Mr. Foster's letter, that the staff continued to use the linear mile after that for another 30 years? Is that,
A road mile.
Road mile.
did I say linear mile?
Yeah. Yes,
See,
I would.
just there's a reason I wanted to get that clarified.
That did occur.
Okay, so he could, you know that the staff continued to use the road mile criteria even after Mr. Foster's letter was rejected.
I guess I would say that that is what they claim. I have no record to show that road mile has been used except for those 3 of 42 locations. So although Planning Commission said no to road mile, the appellant claims that over the past 30 years, though, road mile has been used.
Okay, and you talk about those 42 at the top of page 12, 11 and 12. The evidence includes a negligible number of total permits. In total, only 3 of the 42 permits. And again, my question would be, of the other 39, there's no mention of either a radial mile or a road mile.
Correct.
Correct. Okay. Numerous permits were erroneously issued in zoning districts where billboards actually are prohibited. Is that relevant to anything?
Just to show the inconsistency.
Yeah, which you're committed to clearing up at some point.
Correct.
Right. Okay, the next paragraph. In the event the city may have previously interpreted the 8 per mile, quote unquote, standard to mean road mile rather than linear mile, the city is not obligated to continue to rely on that interpretation once it determines it is not correct. I guess the thing that stands out is the city is not obligated. Is there a word that should be going in there before obligated, like legally or morally or ethically or something like that?
Mr. Mays?
Yes.
I wrote that sentence.
Mhm.
And that sentence comes more or less word for word from the Oregon Land Use Board of Appeals in a case I should have cited here, but I didn't want to make this into a legal memo. And that was the holding that the court found. And to continue on making mistakes just for the sake of, well, that's how we've always done it. Oregon law is clear. We are not obligated to do that. It would be ridiculous. And such a notion would have serious legal implications in all aspects of municipal business. But nonetheless, that is the holding currently applicable to situations like this in the context of that paragraph.
Okay, and it goes on to say that if the city determines previous permits were issued in error, it can correct those errors and now apply the code as written. So that's another way of saying that all previous permits were issued in error, and therefore we can correct that by going with a linear mile measurement from here on out. Is that a correct interpretation?
No, I also wrote that. It is not speaking at all about whether those permits were issued erroneously or not. That sentence merely indicates, sort of to underscore the previous sentence, that if the city determines previous permits were issued in error, we now have a chance. Every new application is a new opportunity to sort of right the ship. There's no prejudice here to the applicant or the appellant, as the case may be, because the implications of the city council denying this appeal is not that billboard gets removed. The billboard stays exactly where it is. You drive by tomorrow, you'll still see it. The only implications are that it won't be any bigger. And so no one is here tonight, or the city does not have the authority actually to go revoking permits once they're lawfully issued. To do so would be unconstitutional in a few different ways, presumably. And so here tonight, I think this is now is as good a time as any to talk about what the implications of the decision are, just to give council some context. And a vote to deny the appeal would be to maintain the status quo for this billboard. And a vote to grant the appeal would be a vote to allow this billboard to become larger.
Okay, I don't want to beat a dead horse, but I want to make sure that this non-conforming issue is thoroughly understood. Should the city council determine that previous permits were issued in error and correct those errors by using the linear mile in the future criteria, would that make any of the billboards of Meadow Outdoor non-conforming? And I'm hearing you say that
no,
there's no.
They cannot be non-conforming unless they lawfully existed at the time of the code's adoption in 1992, and they don't meet the chapter's requirements. And they could be non-conforming if they met those two requirements. For this application, that is not the case. The billboard was apparently constructed in 2003, 10 years minimum, at least, or around 10 years after the code was adopted. It can never be a non-conforming sign.
Okay.
Mayor Mays, if I may, again, just
Sure.
to illuminate the issue, I think the billboards that were approved where they shouldn't be is a good example. I don't know whether they were approved before or after 1992, so I'm not going to get into the non-conforming issue, but presumably those permits shouldn't have been issued, but the appeal period is passed. The property owner has a valid permit for it. There's nothing you can do about those. You have to live with that mistake, but that doesn't mean you have to continue issuing permits for signs where they don't belong, where your sign code doesn't allow them. Just because you've made a mistake in the past doesn't mean you have to continue making it. So yes, the city may have interpreted the number of signs per mile standard either linearly or per road mile in the past. But if you determine the road mile interpretation was incorrect, that does not mean you have to keep making the same mistake. You have the opportunity tonight to affirmatively state what you declare to be an interpretation of that code provision, and staff and the rest of us will go forward with that interpretation.
I think the concern here is more with the existing billboards than it is future billboards, but I'm not going to speak for the appellant, so we'll just leave it at that. Okay. I thought I heard you say that since from 1992 to present day that the road mile criteria was used. Doesn't it really go back to 1974?
But the
Road mile criteria has been used since 1974, not since 1992.
Anyways, I can jump in. Josh, if you want to take a look on page 13, underneath, well, the middle of the page. Mr. Mays, I think what you're referring to is the appellant's argument. I do not understand that the city staff believes that to be necessarily the case, as evidenced by that paragraph indicating historical research found that only 7% of all billboard permits in the city reference any mention of a road mile measurement, even going back to 1974.
Okay. Okay. Page 13. You mentioned that Jim Foster letter again. I think we've already addressed that, right?
Yep.
Okay. Further down on page 13, about midway down, with the paragraph beginning, appellant argues the city has approved the placement of billboards based on a road mile measurement since 1974. That's the appellant's opinion. However, historical research found that only 7% of all billboard permits in the city reference the road mile. Did you find any evidence that any of the permits, the other 93%, mentioned linear mile measurement?
No.
Okay.
And a quick clarification on that. 7% of all billboard permits should be replaced with billboard locations, to be very clear about that. There's billboards that have multiple permits throughout their existence.
Mm-hmm.
However, only 3 of the locations ever mentioned the road mile, or ever had any mention of a road mile measurement.
Okay, my last question before I go to Counselor McLaughlin, on page 15. Second paragraph. This alludes to attachment 9, which is the letter on June 22nd to Chris Zukin. Staff offered to collaborate with the appellant along with additional community input on proposed amendments to the sign code that would have allowed both the city and the appellant to begin a comprehensive sign code amendment. Staff explained that once the appeal is filed, the city instead focuses on defending the appeal. And then the sentence below that, and then it takes up one paragraph, says the appellant failed to respond to the staff's request. There was absolutely no response from that letter at all.
No response.
So from there was no communication between the city staff and Meadow Outdoor between June 22nd and when the appeal was filed on July 7th, correct?
Correct.
Okay, thank you. President McLaughlin?
I'm going to withhold any questions at this time and defer to Counselor Long.
Okay, Counselor Long?
Well, I was going to defer, but I do have one question right now. So even though you're saying that the specific mention of the type of mile was only mentioned in 3% of, or in 7% of the cases, did you calculate if any of that was just approved based on the assumption, the working knowledge that that's how things worked, and so it wasn't specifically written out into the requests for the permits?
It was rather unclear because they happened at different times, spread along the course of so many years. So you could have one permit that didn't mention it, the next permit mentioned it, permit right after it had no mention of it. So if there was internal dialogue within the planning department office, I have no record to show that that was how we did things by any means.
Well, other than if it was approved, and it could have only been approved if that was the case, right?
And yes, but I mean, like I'm saying, that it was sporadic. That, I mean, it seems one permit, there was reference to it, and the very next permit in line, there was no reference to it.
Right, but I'm saying regardless of reference, even if there's no reference, if the permit was approved and it would have had to have fallen under that criteria, did you check that to see how many? Because that would indicate a working practice of not having it specified, but being an understood way of having it approved.
I would just claim inconsistency.
Okay, so you're not sure, you didn't check that?
I guess I checked through them. I guess I'm a little unclear maybe on the question.
So what I'm saying is, if someone put in a permit, and even if it doesn't specify how the mileage is to be measured, but the permit got approved, and if you looked at it and it could have only been approved with the interpretation, which seems to be the working interpretation of the road mile, how many times did that happen?
So I did not dig into as far as breaking down each permit and the location. No, I did not. It would have taken the amount of time we spent researching all the permits already. That would have taken that much more time. But, you know, to your point.
Thank you, Councilor Long. I think one of the points as staff are making here is that, and again, the number of billboards that were approved in places where they just weren't even allowed by the zoning indicates there was not a consistent adherence to the approval criteria over the years, whether it was the number of signs per mile, how you interpret mile, what zones they were allowed in. There was just a lot of inconsistent practice. I don't think we can, I certainly wouldn't conclude from the fact that a number of permits were issued at a density greater than 8 per linear mile indicates a pattern or practice within the Department of interpreting the code a particular way. There's just too much inconsistency to reach that conclusion.
Okay. So So my concern as a city councilor is policy and what is best for the city, not parsing things out legally, and I'm starting to feel like this is parsed, but for now, that's my only question.
Mayor Mays, can I just address that last comment?
Sure.
Councilor Long, you're absolutely right. And, as I think I've been city attorney since August 2020, and I believe that this is the second quasi judicial public hearing that's come before the city council in a contentious kind of way in the context of a land use matter. It's important to remember, I believe the last one was Chris Queen was here, and it was done on Zoom for the Legacy subdivision. This council here tonight, while this hearing is open, and you all heard Mayor Mays bang the gavel, you're not acting in your capacity as legislators, which is typically how you're acting. You're acting as the policymakers for the city. But here tonight, and that this is exactly why it feels a little parsed. It's because it is. You're acting as a judge. And this is certainly, getting into the nitty gritty of the legalities of it all. Chris Green, whenever he speaks, you can think of him as the city attorney on that matter. And for the rest of this hearing, Chris Green is the city attorney as well. As an expert in dealing with Oregon land use, his opinion is second to none as far as I'm concerned. But what he said, it makes sense to me. And I want you to know, and I want you all to know that when you're acting as the judge, you shouldn't be thinking about the policy implications. Your only question, which, and I know it seems counterintuitive, the only question that should be going through your head when you're going through the rest of this hearing is, what was the city council's intent in 1992 when they adopted the sign code? And to get there, Oregon law is pretty clear in the world of land use. You have to start parsing things out and looking at the text in context of its legislative history. That's all. Just wanted to give some additional context for everybody.
So then I have another follow-up question to that. So are you saying that in this hearing, we can't take into consideration the policy that we want, and there would be a separate process to do that if we determine that we, for example, did want to allow this billboard, that this might not be the appropriate venue to do that, but that we have ability to do that?
That's exactly right. And the decision before you, again, this is a controversy, right? Case in controversy, as the lawyers use that term. There's an application here, and the application is, the appellant submitted it to appeal the planning commission's decision. And so that's the decision in front of you. It has nothing to do with the policy implications of the decision. However, staff just presented some of the, quote unquote, policy implications of either one of these interpretations, in fact, both of them. That can only be used by the decision maker, this council, to infer the intent of the council when it adopted the sign code. And you can think of it like, using one of those slides, it showed how many, like 150 billboards if you follow appellant's interpretation. This seems like a policy question, right? It's like, well, do we really want 150 billboards? But that's not the right way to think of it in this context. It's really, would the council in 1992 that adopted this code is that what they wanted? Did they want 150 billboards? Because if so, then we'll go with that interpretation. That's the proper way to think about it. To address the second part of your question, this is not the appropriate forum to discuss policy. However, 2 weeks from tonight, or a month from tonight, it absolutely could be in the context of a discussion item. In fact, it would be appropriate after the decision is made here tonight for the mayor to talk to the city manager to instruct staff to come back with some recommendations for updates to the sign code, because we can certainly do better, and we can avoid this from happening again in the future by implementing some, with certainty, some clarification as to the way that these kinds of things should be addressed. But in this specific instance, for the rest of this public hearing on this particular quasi-judicial issue, the focus cannot be on the policy. It cannot be on what would you rather like to see. We can go forth and update legislatively the sign code at any time. This council can have 5 billboards per square inch, right? Realistically, whatever it wants, the city council has full authority. We have home rule jurisdiction here, but not in the context of a quasi-judicial land use hearing. In this case, you guys are the judge, just the judge.
Okay, thank you.
You're very welcome.
I have a question about that intent issue, but I'll ask it at the end. Let's get the other counselors.
Mayor Mays, I need clarification. We're quoting 1992, but wasn't the original ordinance made in 1974?
Mayor Mays, Councilor McLaughlin, uh, ultimately, at the end of the day, this comes down to how would a court look at this decision if it came to, or more specifically, the Land Use Board of Appeals, and the courts will defer to a local government's interpretation of its own ordinance. The theory is that no one knows what was intended better than the governing body that oversees and implements its own code. Even if you weren't in office in 1992 or 1974, no one is closer to the subject, and the courts will defer to your interpretation of your code. To reinforce what Mr. Kara was just saying, therefore, it is the code criteria that are relevant tonight. If they, and you're limited to the language of the code criteria. And so your job is to interpret these code criteria. What does the code mean when it says shall not exceed 8 per mile? You're limited to that language and what you think that means. And as long as your interpretation is plausible, the courts will defer to it. But if that doesn't capture what you believe the policy should be, give us direction to engage in some code amendments, and we'll come back to you with some recommendations for what the code could read to achieve the policy goals you believe are advantageous. But tonight you're stuck to the language of the code, and the courts will defer to your interpretation, and just yours, not the planning commission's, not mine, not the appellant's, no one else's. The only thing that matters is your interpretation of your code, because the courts will defer to that.
I understand that. In 1992, there was a appellant request for adding road mile to the language. And you said that it was not, there was no action taken. And why was it ignored? Why was there no action? Is there any historical data?
I can't speak to why it was ignored.
Because that would have alleviated all of this tonight if they would have adopted at that particular time, whether it's linear or if it's road mile.
Correct. I would have.
All right. Thank you.
Counselor Randall.
Thank you, Mayor Mays. If the sign in question cannot be non-conforming as is, how does it become non-conforming if it's enlarged?
It won't become non-conforming.
Mr. Mays,
Yes. please.
Councilor Randall, the community development director is correct. It would not become non-conforming. It just wouldn't meet the code's standards because it would violate its existence because of this new. This is sort of indicated earlier that the only reason any of us are here tonight is because the appellant submitted an application for for enlarging this sign with a new larger sign. And so when city staff gets a new permit application, they look to the code. They say, okay, well, let's look at the application. Let's see how it meets our code, or if it doesn't, and we'll figure out a path forward. And when you get to the box where you have to check it to see whether it meets the 8 per mile standard, it doesn't meet that standard. And that's the issue in this appeal.
So the request for the permit is what brings it to light.
That's exactly right. This isn't just Josh and I bored on a Sunday going around town looking for signs. This is only here because appellant submitted a request for enlarging this billboard. And as a result of that request, it triggered staff's obligation to process the application. That obligation is a function of the municipal code. The municipal code is our universe where we look to council's policy, which is how which is adopted through ordinance to inform staff decision making. And in context, that sentence is interpreted as, the way that staff's recommending it be interpreted as the crow flies. To do anything else would be, something else entirely. Hopefully that clarifies a little bit of your question.
Mr. Chandler, how are parallel streets evaluated? Couldn't there be more than 8 per road mile along, or could there be 8 per road mile along parallel streets where you'd have 16 signs within a mile if you're going along the road measurement?
You could, yes. Yeah, so it doesn't, if you look at the, our city street grid, you could, if you go off of the road mile interpretation, first, second, third, fourth, fifth, sixth, every single street could potentially have 8 per mile.
And finally, my last question is, were the spacing and measurement standards in existence when the ordinance was passed in 1992?
For the spacing, they were,
Where it deals with the topography and the horizontal measurements. When did those come into effect?
I know for sure 1998 is when the current, well, I would have to look to see when those sections were specifically added to the code, but the code was created in 98.
Mr. Mays, I can try to check that for you, Councilor Randall. That's an excellent question.
Okay, while he's looking that up, did you have another question, Mr. Council Randall?
That was it.
Councilor Richardson?
Thank you. A comment and a question or two. The comment is a somewhat, according to what City Attorney Karras described, as a somewhat more restrictive conversation than I thought we'd be having this evening. But be that as it may, first question is, has anyone looked at records or minutes from city council meetings in 1992 that might have had discussions of the request to add or not add the road mile standard?
Did some research in it, minutes from planning commission meetings, and didn't see much of a mention on it. The minutes were a bit vague.
Perhaps the appellant may have done some research. We'll get into that when they make their presentation.
There's a map on page 513 of our packet. There's discussion of a map made between Meadows staff and planning staff back in the day, some years back, that essentially laid out, if I understand right, laid out a common understanding of where they thought signs would be allowed. Have you seen that or found that map by chance?
Yeah, it was included in the packet. I think there's that packet of about 300 documents pertaining to permits. Yes, and I think it's on graph paper, and it's provided showing distances between different signs.
So I guess my point being is there was at some point, some document showing some attempt to add a common understanding between staff and Meadows.
At that time, it was, yes, I would have to say that there was, those dimensions were provided.
I take your point that may not be binding now, but there was that effort. So I confess I'm a little unclear on the impact, and I would like to be crystal clear on the impact of tonight's decision. Is it the fate of one billboard? Is it the fate of many billboards potentially?
Well, the fate would be based on when a permit comes in to be reconstructed.
There's a number of the 42 that you have no records for, no permit documentation for.
We have permit documentation, just not, there's no mention in that permit documentation of this road mile being used.
Correct. All right.
So the fate tonight, really, if this appeal is denied, the sign stays where it's at.
Correct. Are we taking down other signs? That was my question.
Not with the decision based tonight, no.
They're essentially grandfathered in.
Well, they would be
regardless of their measurement as the crow flies.
Correct. And the minute that they would come in to reconstruct that permit, we would take a look to see what the distance measurement is.
How about to repair one of these grandfathered other 41 billboards?
There is routine maintenance that wouldn't require a permit, but any of the structural alterations that would be made. I know typically, I think the older billboards had 4 posts that used to hold them up. Now they're going to more of a monopole. And if you're going from that 4 post to the monopole, I would say that's definitely a structural alteration, or increasing the size would be a structural alteration.
So potentially there's an effect on on a wider range of boards over the years. We could assume that.
If they were to come in for a permit, we would definitely take a look at that.
Okay. My understanding is that staff has in mind to bring some potential revisions or clarifications to our sign codes at some point. I think I saw, or maybe I just was hoping for a period of something like in the next 6 to 12 months. Do you have a time frame for when that might be coming down the road for us?
Well, in all honesty, I had hoped to tackle that this fall, to at least have initial discussions with Planning Commission. But this has really absorbed a lot of time, this appeal.
Fair enough. So I don't want to just operate on an assumption here. I want to get your sense of this. My previous question suggested that tonight's decision may have the scope of it may be beyond a single billboard, maybe a number. However, it sounds like the duration of the impact could be pretty short if we're going to be looking at sign code language in a sort of holistic or global fashion. Does that sound accurate to you, or does that make sense? If we say go forth under this philosophy, the road mile or the linear mile, either one, and then we're discussing sign codes in total, 6 months from now, the duration of this decision may be short-lived.
Correct.
All right. That's all for right now.
Mayor Mays, I just wanted to jump in. It's proving extremely challenging to do this on my iPhone. And so I'll try my best to dig into the legislative history to find out the adoption of that provision that Councilor Randall mentioned. And I'll try to report back at least to the council as soon as I can, more than likely later this week.
Thank you. Sure. Councilor Runyon.
Okay. First of all, this permit was approved at one point. I read in the packet. Is that correct?
Yes, we had a short-time staffer with us. He thought it was merely for routine maintenance. So it was approved, thinking it was for routine maintenance. This is the conversation that I had with him. He's no longer with the city. And then the appellant reached out to me, questioned why it was approved, and I let them know it was approved incorrectly.
And disregarding size, looking at safety and whatnot, if a 4-post signboard, billboard was out there and putting a monopole under it would be a safety issue to keep that board from becoming derelict in its duty. That wouldn't be an approved function.
Well, I guess
even if the sign was left the same size.
Well, I guess if you're making, I would just look at, you are modifying the structure. So if you are modifying the structure, even to make it a safer sign, you're still modifying the structure, therefore requiring a permit.
So just let it fall down. Okay. All right. I don't want to spend a lot of time at this point because I want to hear from the citizens within the room who've given up their time to be here tonight, and I appreciate that. I, like the others here, have spent better part of the last week reading every day over and over and over again and making notes. A lengthy document, our entire document's basically 600 pages. Most of that has to do with this. Yeah. I've driven up and down West 2nd Street. Driving, I went from a half mile prior to the subject property to a half mile past it. I also plotted a course west from a mile before the property and then a mile west of the property. And I go, because everything that I read in here on so many pages, which I'll note in a moment, doesn't talk about radial. Radial is mentioned basically on page 11 and page 57. And I noticed in your opening remarks, you were real careful to insert the word radial in the measurement to the center of the street. And my question is, of 30 years of using the same basic criteria that talks about no more than 8, and let's see here, did I find the right, so I quote it correctly, when measured at right angles to the street or highway center line to which the sign is oriented, or simply measured at right angles to the street center line. That's what people were seeing for the last 30 years, looking at everything's measured to the street. Even buildings are measured by their frontage to the street. That's in the staff report as well. And I'm not looking at the appellant's comments. Everything I've looked at is in the staff report. And it's just, it's mind-boggling that it's radial. And then I looked up the dictionary reference to lineal and linear or linear, composed or arranged in lines, not as a crow flies. That's just very confusing. I don't think the city even owns a crow, do we? No. Anyway, you said only 3 of 42 permits reference any mention of 8 per mile, or apparently any note about distance. That's in the staff report. Staff notes that means no evidence to support the appellant's claim. That's what you wrote there. However, in my opinion, it could also mean the distances were noted as a given at a time of the permit request over the decades and approved as such. So there was no issue made of it, is why you didn't find it, because it didn't come up. So we've been doing it that way for 30 years, and I'm just having some fairness issues. Thoughts about that or those comments?
Yeah, I guess my comment would be the appellant tried to clarify this in 1992 by adding the road mile at the planning commission, and the planning commission said no to that.
They didn't say no, they didn't say yes.
They didn't say no.
There's
they didn't
no,
say yes. Correct.
Yeah.
there's no record. I was flipping through this big packet, and I'm sorry to jump in, Rod. May I?
Let me finish this and I'll.
Sorry.
On page 12, 1974 to 1992, 1992 to present, it lists numerous notations within the nearly 600 pages list when measured along the street center line. And I just come back to that as I go through this extremely laborious packet. Anyway, and it's no wonder that people have made a mistake all these years, I guess, because it's written in black and whites on so many pages within the book. In fact, wow, on 7 different pages, I found that notation about the distance to the center line 13 times on 7 different pages in the staff report, as many as 3 times each on pages 12 and 17, twice each on pages 19 and 49. In my opinion, clearly not a radial measurement. To draw that circle and look clear from Cherry Heights on over to 6th Street, and I think there was one dot even further than that, because it's not a mile to 6th Street. It just has nothing to do with the street where the signs are located. And I didn't count 8 in either one of those half miles, but the circle, those blocks. I don't know. I know this is an interpretation and not, but it sounds like we're doing a policy change. And that's, when I was on the planning commission in the 90s, that's not the way we did policy changes. Planning commission merely did a review with the director, who's in the audience here tonight. And then it was taken to the council to do a policy change. But you're saying that this is not a policy change. This was a policy all along. And that this is just the correct interpretation. Is that right?
Correct.
That's all I got for now.
Counselor Long.
Yep. So I think a little bit like Counselor Richardson, I thought we were having a different discussion tonight than what our attorney, Mr. Kara, just described to us. And so based on the packet here, if we're supposed to decide what the intent was in 1992, all we have are the documents that were submitted. We don't have actual minutes and to understand how they interpreted that. So I'm not really feeling like we were provided with enough information to solve that question. Seems like we were steered toward the question of whether or not this should be allowed. So I just wanted to say that, like, if we're supposed to know what they intended in 1992, how would we know that?
Mayor Mays, Counselor Long, you can't put yourself back in the shoes of people that were there in 1992. There are things you look to try to determine what you believe the legislative intent was. Legislative history is one, but we know the legislative history in this case is pretty thin. So then you look at things like what does the language of the code provision say? If it was well written, it should capture that policy. What is the text? How do you understand that text when you read it in context with other provisions? Like when it says 8 per linear mile, you've got other code sections that instruct you on how to determine distances, for example. So you read the text in context, the legislative history, and all of that is supposed to help you understand what you believe to be the policy that is captured by that code provision. And however you interpret that, the courts will defer to that. But obviously you're not a mind reader, and you're not going to go back to 1992 and understand exactly what they intended. You have to look at the text in context, whatever the legislative history helps you with, and then make your own decision about what you believe the intent is.
Well, that actually is exactly my point. I'm not a mind reader. So where are the minutes with the discussion about so I don't have to read their mind?
Right. And the minutes, to the extent Mr. Chandler said, the minutes are really vague and not very helpful. He and his staff did that research.
Right. So that's kind of the point, is that we're here because nobody can figure out what's what.
But the point is that the legislative history is not very helpful. So instead you have to rely on the text in context. What does the text of the provision say? Where is it placed within the code? What other code provisions illuminate that text? Because legislative history isn't very helpful. So you have to rely on other things.
And we do have the history of what people did afterward.
Or and after, right.
Thank
Well,
you.
regarding this intent issue, we don't know, because we don't have the minutes, or the minutes were vague, but we do have testimony from the Planning Commission chair at the time, 1992, who sent a letter to the city supporting the road mile interpretation. We also have the testimony from the planning director in 1992 testifying to the road mile criteria. Who would be better qualified than those two gentlemen to be able to determine what the intent was of the city council in 1992 than those two?
Yeah, it's certainly evidence, but I can tell you a real quick story. My first six years of my practice was at Legislative Council in Salem, where I drafted the state planning statutes. And people would call me up afterwards when one of those statutes would end up in a court case, and they'd say, well, Chris, what did you mean when you wrote this provision? And I'd say, it doesn't matter what I meant. What matters is what the legislators thought it meant when they voted for it. What I, as staff, thought doesn't matter. The courts will not defer to staff's interpretation. So maybe you find that information helpful, but it's not legally particularly relevant.
Okay. Any other questions before we move to the appellant's testimony? Please proceed, Mr. Zukin.
Thank you. My name is Chris Zukin. I live at 5525 Cherry Heights Road in the Dalles, and I'm the general manager of Meadow Outdoor Advertising. I'd like to go get a poster board. I will say, first of all, that this is a friendly crowd. We are here to listen and smile. Only 7 of us are going to speak, so this is not going to go on and on and on. Everyone here is friendly and smiling, right? Yep. That guy presents.
Oh, yeah.
All right. So far. Honorable Mayor and City Councilors, this is not a complicated issue. And it is frankly not worth 600 pages of record or evidence. The issue boils down to one line in the sign code that was originally adopted in 1974. And it's on that poster board. The maximum number of advertising signs shall not exceed 8 per mile, with no more than 5 on the same side of the street. 8 per mile per street. The intent of that city council was to control the number of billboards one would see as you drove down the road, I-84 or 6th, transitioning to 3rd as you came into downtown, to avoid a picket fence effect. So you wouldn't have billboard, 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 not more than 8 per mile. The intent of that line of code is that there would be no more than 8 billboards per linear mile. And when I say linear, I mean road. And you'll, unfortunately, staff mentioned that linear does not mean road. We use linear all the time in our argument. So to us, it does mean road. The current planning department is interpreting this line to mean 1 radial mile, much more restrictive than road mile. Our sign code was reviewed in 1981, 1992, and 2007, and this wording was not changed. And we were talking about the Planning Commission meeting in 1992. I did look at those minutes. And there were several items on that Planning Commission agenda. The sign code came on like at 9 o'clock at night. And the minutes were really pretty good up until the sign code discussion. And then there was a paragraph that said there was a lot of discussion about the sign code and they decided to leave it the same. But if you look at Mr. Foster's letter at the very last paragraph, he's writing to planning commissioners. He says, my second and final concern I have is the new sentence that's been added at the end of the first paragraph of section 5.180. The inclusion of that language would dramatically reduce the number of signs currently in use by my client. It creates a limitation based on 1 square mile rather than road mile. So that was the proposal that evening, was to change the code from 8 per mile to 8 per square mile. And that planning department said, we're not doing square mile, we're not doing road mile, we're just leaving it the same. Square mile is very similar to radial mile. And I think this is very clear evidence of the intent of that planning commission in 1992 to not go radially or square, but to stay road. And I also will mention regarding the 7%, the 3 out of 42 that mentioned 8 per mile. Frankly, that's irrelevant because we don't know if they meant 8 per radial mile or 8 per linear mile or 8 per road mile. They didn't say which one of those 3 they were notating on those permits. They just said 8 per mile. So that really doesn't matter. What does matter is that for over 50 years and by at least 7 city planners, this line has been interpreted to mean 8 billboards per road mile. And so what? What's the big deal? The radial mile interpretation makes all of our billboards in the Dalles non-conforming. And by non-conforming, I mean that they do not conform to the 8 per mile interpretation, which means none of them, we can't build any new billboards in the Dalles with that interpretation, but we also cannot rebuild, replace, or relocate any of our billboards as long as that interpretation is intact. This will result in economic loss, and it does threaten our future in the Dalles. The intent of the City Council in 1974 was to control the number of billboards in a road mile. And we hope the intent of this City Council is to maintain that original intent and to instruct the planning department to interpret this line of code as road mile. Thank you.
Thank you. Is there someone else that would, you said there were 7 people?
There are 7 people. And next on the agenda is Mr. Rob Van Cleve.
Before we get to Mr. Van Cleve, does anyone have any questions for Mr. Zukin? Thank you.
I guess I do.
Oh, go ahead, Councilor Richardson.
Sorry, I thought you were gonna follow the same pattern.
I didn't hear anybody else.
Mr. Zukin, help me understand. I don't know if our attorney's gonna say this is a fair game or not, but I'm really curious. So help me understand, if you would, why not work? Why not put your efforts into helping staff clarify and revise the sign code? We have to do that anyway. It's a mess.
Couple reasons. First of all, I think that was putting the horse before the cart or the cart before the horse. Why change the code internally before you go to a sign code review? It would have been much more appropriate to go ahead and start the sign code review and then for staff to suggest that the wording be changed from per mile to radial mile. And frankly, I also believe that staff had an agenda regarding billboards and it was not a favorable one.
I'm not going to argue with you on that, but they don't make that decision, right? They bring suggestions and then we have, and I guess I'm poking at this a little bit because I feel that this is not a good way to do policy, in a 2-hour time frame. So whether or not we're allowed to talk about that much, that is definitely on my mind. This is not the way to do that. And having a calm, measured discussion where we can think about it and sleep on it, et cetera. That's the way to do that.
I totally agree. And that's why we're here, because we felt a policy decision was made by staff and it should not have been. We didn't want to go into a sign code revision with the sign code being interpreted in what we felt was an incorrect way. Again, we felt that was wrong timing. But let's go ahead and start the sign code review, but let's not change the sign code first.
Thank you.
Counselor McLaughlin, I missed the due.
No, no, I'm going to defer. I've got some questions, but no, none at this time.
Was your explanation that you just gave a reason why you didn't respond to the June 22nd letter?
You know, I honestly don't remember whether I responded or not, frankly. Staff says I didn't, I must not have. I don't remember if I just said, let's move forward with the appeal or not. Obviously I didn't. I can't respond.
Okay. Mr. Van Cleve, you want to come on up?
And Mr. Duro.
Mr.
Thank you.
Good evening, Honorable Mayor and City Councilors.
Could you talk into the mic? Could you talk right into the microphone, please?
My name is Rob Van Cleve, 1325 Sterling Drive. I'm here with Dan Duro this evening to support Meadow Outdoor in their efforts this evening. First, I'd like to mention there's a lot of people in this room behind me who have sat in the chairs you're sitting in now. And we all understand the time and commitment it takes to do the jobs you do. What you do matters and it's appreciated. And I want to thank each of you individually for your commitment to our community. Second, I want to reaffirm what Chris stated in his opening testimony. I can state that during my 14 years as a counselor and as a mayor, the standard that Chris described was the standard used in those 14 years. And Mr. Mayor, I don't mean any disrespect to the process. Chris, don't get nervous. I realize this is a quasi-judicial hearing, but we're not Portland and we're not Seattle, and integrity matters. And Chris Zukin's a very honorable man. And you can believe Chris Zukin. He's one of the most honest and honorable men I've ever known. And finally, my main reason this evening is to introduce another honorable man. During my 14 years, I had the honor, as did many other people, to have a community development director named Dan Duro. And much of what we see in this community today that we honor and respect and look at and cherish started in this man's head and in this man's heart. He's very passionate about this community. He's very honest, conscientious, detail-oriented, and was an amazing planning director for the city of the Dalles. And with that, Mr. Mayor, I'll move the mic over to Mr. Duro.
I think I need to buy a new hat. My head's getting bigger. Thank you, Rob, for those kind comments. First of all, Chris, if you hand out those. Chris is finding written testimony for this hearing. I had submitted something for the Planning Commission. I revised it slightly for this hearing, and I'm going to refer to a diagram that I have in the back, so I want you all to see that. And I don't have all the electronics here to put it up on the screen. I was asked by the applicant, in this case, the appellant, to come and speak on his behalf. But really, I'm here to help the council understand in a more neutral way the legislative history as I remember it, and to talk a little bit more about this key sentence here, and also the other sentence about measuring the horizontal measuring distances. So I was here in '92 when that major sign code amendment was made. Scott Kyler headed that process up under my supervision. And we had a number of hearings. And I remember commenting at the staff level after the meetings, just how many attorneys show up whenever you have a sign code amendment. They seem to come out in droves. at these hearings because it's an important issue, obviously, to not only the sign companies, but I think to the general population at large. And in terms of this measurement, had any discussion come up about an area measurement, that certainly would have changed a lot, changed the way we interpreted the ordinance, the way we applied the provisions of the ordinance over the years. And it certainly would have caused the attorneys to speak up loud and clear for the clients, because it simply wouldn't make any sense. And so I do not recall any discussion about an area measurement being used to approve sign applications, nor did we use that as our criteria over the 22 years that I was here. So the current staff, when you look at the sentence that says the maximum number of advertising signs shall not exceed 8 per mile, they inserted linear. And when you Google linear, it's pretty clear that a linear measurement is a single dimension. It's in one dimension and it is a straight line, not a curved line. It's a straight line, which becomes automatically problematic when you look at our street system. Now, for most of our streets, they're straight for blocks and blocks, but at some point they turn because this community follows the curve of the river. And so you're going to have a bend somewhere along the streets or a curvy street. And when you use linear, it's just problematic in trying to measure as the rest of the sentence requires you to measure. You can't do it. But if that were the only issue here, I may not even have come tonight to try to clarify things, because that may be just an interpretation made. But what happens is the staff then goes from that, making a quantum leap into a second dimension, which causes this to be an area measurement. And that simply was not discussed. It may have been discussed in terms of a square mile. I don't recall that, but it was certainly not included in this language. So when you read this, it says no more than 8 per mile with no more than 5 on one side of the street, not all the streets within the 3.14159, you know the number, square miles, which equates to over 2,000 acres of land area. It says one side of the street and no closer than 300 feet apart when measured at right angles to the street center line to which the sign is oriented. Now, how in the world would you, how do you apply that to an area when it specifically is talking about the street on which the sign is located? And it doesn't make any sense. And that's certainly not the way we interpreted it. It's not the way we applied the language over 22 years that I was here. So then if you look at the second page of my handout, where it talks about the section 10.6.070, et cetera, distances are measured horizontally. Now this whole sentence or paragraph really refers to this diagram here in terms of measuring. So the diagram was similar to the one that was put up on the screen earlier. But as you can see, I've drawn something very similar. There's a horizontal distance, which is shown on the bottom of the page. And then that point where the yellow triangle comes together, where we start the measurements of 20 feet, that represents the property line. I didn't write that on there, but that would be the property line. So if you measure a setback on an angle shown there of 20 feet, and you draw a vertical line then down to the horizontal line, that becomes different than if you simply measure the 20 feet from that property line back. So you have a difference of X depending on the slope. And this came up when you look at our community, we had issues about setbacks over the years. And we're in a bowl. And if generally speaking, the farther away you get from the river, the steeper the land gets. And we have some fairly steep property around here. And the intent of this language in this section was to make sure that the setbacks were measured on a horizontal distance so that you didn't have the encroachment into what would be the setback area for any structure. And this would include a sign structure as well. Now, could that language have been more artfully written? Yes. I think if you took the current ordinance and you tried to create an ordinance that could really only be interpreted one way, you would have a stack, you'd have a document a mile high. It's simply, it's difficult, especially when you're getting input from a number of sources as to how the language should be written. It's sometimes difficult to write that very artfully. So the term topography, I know this has been brought up, and I think brought up in a confusing way, simply meant slope. We could have used slope. If you look up the various definitions and uses of the term topography, slope is one of those. It's in there. And that's how it was to be used, because this community is on a slope, a lot of it. And that's how we worked with it over the years. Going back to the key sentence here, the issue, the staff's interpretation of inserting linear per linear mile is problematic. And then it's the quantum leap from there to another dimension, which makes it an area measurement. And that simply wasn't, I'm sorry that the minutes didn't appear better than they did. But certainly if that was the intent of the Planning Commission and the intent of the City Council, it would have been our job to implement it that way. And we didn't. We implemented it on a per mile, road mile basis. So I guess, if there are any questions.
Any questions of Mr. Van Cleve or Mr. Duro?
I have one, Mr. Mayor, if you may.
Councilor Richardson.
Thank you for your time this evening, gentlemen. I take your point and I grasp it. I will say, this is a comment, I guess, seeking a thought or a reply. Given this map that we were provided showing the potential sign placements, billboard placements, according to the, we'll call it the road mile interpretation, it's something like 170 potential sign locations. Does that sound right to you? That's a somewhat shocking number.
It is a shock. It doesn't sound right to me. I didn't really analyze the staff's discussion on that. I can tell you though, comes a point when you have a certain number of signs or billboard signs where you have diminishing returns on the value of those signs.
Sure, but that's up to the landowner and the business, right? That's not something that the staff is going to interject itself into.
Yeah. And I mentioned in here, the intent of this sign code was to strike a balance between the needs of the traveling public and the business community to advertise, and the needs of the traveling public to get information, and the aesthetics. And and that's a policy choice. You could say that this 8 per mile is simply too many, or maybe it's not enough. Maybe we could allow more.
I don't know about that, but 170 in the town would be shocking to, I think, many people.
Yes, and yeah.
Thank you for your time this evening and bringing your thoughts and recollections on this. Mr. Mayor.
Question.
Councilor Randall.
Thank you, Mr. Mayor. Mr. Duro, I do have a question, and I'm maybe a little confused about the difference between radial, or I should, yeah, radial and lineal. So my understanding is from that particular sign in question, we would go lineally in a radius in any direction to see if there's 8 other signs. But you're saying it's the 1 mile radius, that entire area, there can be no more than 8 signs. Is that what?
Well, I'm not sure how the staff's interpreting that, but when you look at the definition of linear or lineal, it's a straight line. It doesn't have any bends to it. That's how you measure it.
I understand, but for the purposes of what we're our criteria, we're looking in one direction linearly, straight line instead of following the road and its contours, which I assume topography would also include contours, and that's where you get the irregularities, I suppose. Whereas a lineal line gives you a little more precision in determining the distance and how many signs are within that 1 mile. So I guess I have 2 questions there. The main one was I didn't understand it to mean that within that radius of 1 mile, which basically is 2 miles.
Right.
If that's that area, you're saying is that's there can be no more than 8 signs in that area. That's what you're thinking the interpretation of the radial mile or the lineal mile is? Because I understood from any particular sign, you would go 1 mile in any particular direction, radially, lineally.
Well,
And then here, like you say, we run basically east-west along 2nd, 3rd, 4th, 6th streets.
it appears that that's the case. You'd have to ask your staff how they interpreted that, but
Because that would greatly restrict the number of signs we could have if we were doing a radius and no more than 8 in a radius.
yeah, absolutely.
That's not the way I understood it. I understood it, like I said, as being from sign A to sign Z has to be within 1 mile. There can be no more in eight of those signs within that lineal distance, but whatever direction you travel. That's my understanding, but maybe Mr. Chandler can give us some clarification on that.
I was consulting here with a special counsel, but I heard Chris let me know the last statement that you made was correct.
So that we're talking in a lineal direction, any direction within that 1 mile distance, no more than 8 signs.
Correct.
And not the entire area of the radius.
Right.
Okay.
And I would comment that if that was the understanding at these legislative hearings, there would be a lot more in the minutes than the sentence that's there, apparently.
Any other
Questions? Mr. Mayor, I have a question.
Yes, please.
Hi, Mr. DeRoe. You and I haven't met. I've seen you talk a couple times, and you were at the Planning Commission meeting, and I was there too. I was sitting over there, though. And I appreciate your insights. I also saw you on Netflix on a documentary once, unrelated to any of this. So big fan. And obviously, I'm the city attorney. I have access to all the city's deep, dark secrets. And by all accounts, you seem to be a pretty decent man. And I think you served your community with a lot of pride and integrity. And so I'll use this opportunity to ask you a question on how do you reconcile the statement that you just made interpreting the Dallas Municipal Code Title 10.6, 0.070, 0.030, A1, which is distances are measured horizontally, with that same code section number 2. And if you have it in front of you, that would be remarkable. If you don't,
I have it. Oh, no, I don't have part 2.
well, number 1 says, and I'll say this quote, distances are measured horizontally. It seems Mr. Crean is going to let you take a look at what number 2 says. And I'm looking for, I guess, just sort of your practical insights. I know you're not an attorney, but
Could you read that, please?
yeah,
For the record?
number 2 says, and I'll say it quote, measurements are shortest distance. When measuring a required distance, such as the minimum distance between a structure and a lot line, but that's just an example, it just says such as, the measurement is made at the shortest distance between the 2 objects. Mr. DeRoe,
Yes.
what's another way to describe the shortest distance between 2 objects?
A straight line.
A straight line. And so using this context, and without looking at the legislative history, because why would we look at the legislative history when the code is clear? Is there any reason why the city staff shouldn't measure everything using a straight line? Unless otherwise indicated?
Because it becomes problematic when you have a curving object to measure, like a roadway.
Sure, which is why we don't care about roadways. We don't care about topography. Otherwise, you're right, it does become problematic. In fact, the most practical solution is to use GIS. Let the satellites do it. Satellites can measure down to a hair with precision. And when we input distances on GIS for sign applications, we go a mile from the center, which is where the application is. To do it another way, you're right, is problematic.
The problem comes with the rest of that sentence, which seems to be ignored.
Yeah, well,
there's no more than 5 on one side of the street and no closer than 300 feet apart when measured at right angles to the street center.
I'm really happy you mentioned that because I actually forgot. I didn't write down my notes. So thanks for reminding me. That sentence, man, it's really badly written. But I think it makes a whole lot of sense if you parse it out into 3 chunks, which is what this community development director and I did, feels like an eternity ago. And it talks about a couple different things. You could talk about 8 per mile. That seems to be a quotient, right? We're talking about a rate or a density, and that's what that is. And then the next part of that sentence says, and thank you so much for your diagram. It says, with no more than 5 on one side of the street, and the is underlined in red. I will say that there's a different part of our code that talks about the way that words are used throughout the code. It's 10.1. 10.1 talks about the meanings of certain words. I can pull up the code, but, and it says nearly word for word, the singular includes the plural, and the plural includes the singular, because the job for the city attorney who writes the code for council to adopt is a big one. And it's nearly impossible to cover every potential factual situation that might arise. And so very clever lawyers decided, you know what, every time we use a singular noun, we also mean plural nouns. And so the argument that I think you're sort of underscoring here, that the fact that it says the street, that means one street, it really means all streets. It means the streets, because the singular includes the plural. That's 10.1 of the municipal code. But the second part of that sentence.
Mr. Mayor, may I say something, please? I feel like our attorney is testifying or cross-examining our witness, and we are here. This right now is supposed to be people speaking in favor of this, and we're an intelligent council. We understand what's in front of us. In the 7 years I've been on council, I've never had an attorney step in this far. And I'm really uncomfortable with it.
Well,
Mayor, if that's the intent of the council, I'll stop. I'm concerned for the city's interests when they hear half truths and half the story is put out. And I'm not saying that there's any dishonesty, but there's been a tremendous amount of work from staff. And so I don't mean to cross-examine Mr. Duro. I just wanted to say I'm a big fan and I appreciate his contributions to this community very much. I mean that so sincerely.
okay. We'll end it with that. I have one question for Mr. Duro. Is anybody else?
No.
You were planning director from 1990 to 2012,
Yes.
22 years. And during that 22-year period, did any member of the city council, the planning commission, a competitor of Meadow Outdoor, or a citizen ever tell you that you were interpreting the code incorrectly?
Not on this one.
Okay.
It may have happened elsewhere. Not that I recall. You know,
Right.
I've been retired for what, 11 years.
Yeah.
So my mind has been elsewhere for 11 years. So trying to recall every time somebody said something to me.
I understand. Yeah. Okay. Thank you.
My name is John Lehman, and I reside at 92464 Biggs Rufus Highway in Rufus, Oregon. Can you hear me okay?
Yes.
Yes.
Honorable Mayor and City Councilors, thank you for being here tonight to hear our appeal. We really appreciate it. I was born and raised in the Dalles, Oregon, and I've worked for Meadow Outdoor Advertising for 32 years, primarily as a regional lease manager, but also as the operations manager for the first 9 years. My duties included finding, permitting, maintaining, and rebuilding new and existing billboard locations in the Dalles and other places. I was the person that went in and talked to the planners each time to obtain permits for these signs. I've worked with many of the City of the Dalles planners and staff, Dan DeRoe, Dick Gassman, Don Hurt, Denise Ball, Scott Kyler, to name a few. The permitting process was the same. So I would go to the planning office to obtain our billboard permits. I usually stand at the counter and I'd talk to Don or Denise or Dick, for instance, or Dan. And we'd look at a line map and locate the proposed sign along the street or highway shown in that line map. And this is an example of a line map for one of our approved signs. The line represents the street or the highway, and locations are by mile point on the sides. We would then take this line map and figure out a mile section of the roadway, a moving mile section, and make sure that not more than 8 billboards were in any 1 mile section that included the proposed sign. So you would move that along here with the proposed sign within these 2 points, making sure there was no more than 8 in any one of those sections. Again, no more than 8 billboards were allowed in any 1 mile section of that road or highway. Once this fact was verified, zoning was checked, and the sign permit was signed off and approved if it met those criteria. A building permit was also required for every sign permit. The city planner would sign off on a state building permit application as well. So as I mentioned, this was the line map, just one of the examples, and it's already contained in the record for this appeal. I wanted you to know that. A map like this was used and discussed every time I went in to obtain a billboard permit. Not exactly like this, but something like this. Every billboard sign permit application, new or rebuilt, was approved based on 8 signs per linear or road mile. And here that shows the road miles. In addition to an approved city sign permit, each billboard that was located along a state highway required a local sign off on an ODOT application by the city. And this was the zoning affidavit portion of the ODOT application. The approval on this zoning affidavit read, and I quote, "The above location and proposed sign complies with all applicable ordinances, plans, rules, and other requirements of the city," unquote. 36 of our 42 total billboards in the Dalles are located along state highways. All 36 of these signs were signed off by a city planner or an assistant city planner. In closing, I would like to impress upon you that the billboard approval policy for the city of the Dalles has been to use linear road miles during my entire 32 years of employment with Meadow Outdoor Advertising. 32 years. Thank you.
Any questions for Mr. Lehman?
No, but I have one.
Counselor McLaughlin, you go ahead.
I heard you mention state highway system, and you probably deal with other municipalities. I know you have signs all over the country. And what is the standard in the state? How can we use that? Is there something that gives us guidance on the state? How do they see sign to sign? Do they see it in a road mile, or do they see it in a, I don't see how it would apply to state, but do you
They
see what I'm
it-
getting?
Yeah, they see it as spacing as a road mile. They use mile points. They're easily measured and accurately measured to figure out distances between signs.
Now, is that stated in a policy in the state?
Is that it?
That's it.
Counselor Richardson.
I have a question for you, Mr. Mayor. Are you keeping an eye on the clock? You said we need to be wrapped up in 2 hours, starting an hour and 55 minutes ago.
Yes, I have been watching the clock and praying that this would go a little faster.
Right. I just didn't want us to make a decision and.
What
turn
time
out
did the
to be-
public hearing start? Do you know?
Like right at 6-ish.
6-ish?
55.
I mean, there's nothing wrong with extending the time. The 2 hours was a goal. If we don't reach the goal, we'll just keep going. I think, I don't think anybody wants to come back another day because we have to make a decision tonight, correct?
Correct.
Oh. I'm sorry, Counselor Richardson, do you have another question?
That was it, Mr. Mayor.
Okay. The map you have there, it's called a line map?
Line map is what we call it.
A line map, and that's attached to each application.
It's not necessarily attached, but each one was brought in, either written up there at the spot and talked about the different billboards that were located along that stretch of road or highway
Mhm.
and where the proposed was. And then looking at a mile distance
Right.
that would contain that.
So if it might not have been attached to the application, but it was certainly reviewed by the planners.
We reviewed this, even if it was on a napkin, we reviewed a line map. And if it met the criteria, the sign permit was approved.
Okay. Mr. Chandler, have you ever seen a line map before?
I have seen a line map when the information was provided in the 300-page packet.
Yeah.
I came across, I looked through every single page and I think I saw 2 in there.
Okay. Were you aware that some of your billboard approvals were done in zones that were not appropriate at the time?
Well, we don't believe that they were at the time, that they were in the correct zones, industrial zones and commercial zones. So no, not until this was brought up.
Okay. Any other questions for Mr. Lehman? Counselor Randall?
Mr. Lehman, the sign in question is on Second Street, correct? Which is a state highway. And so that's a pretty linear measurement. It's a straight line pretty much along that. So is the reason this is an issue because we have more than 8 along that lineal mile along 2nd Avenue or 2nd Street?
It's the 8 are not all on 2nd Street.
Okay. So that gets back to the radial distance.
Correct.
Okay.
Any other questions for Mr. Lehman? Thank you, sir.
Yeah, thank you very much.
Good job.
Lawrence.
Steve Lawrence, 2017 View Court, the Dalles, 97058. By the way, I've read the entire packet. Statutory construction begins with looking at the plain language of the statute to determine its original intent. To determine a statute, or in this case, code, original intent, courts first look to the words of the statute and apply their usual and ordinary meanings. Second, while I don't see any ambiguity where there can be perceived to be more than one interpretation of code, the language is always construed against the party who drafted it, that being the city. This matter before the council is a classic example of just that. Do not be overwhelmed by the legalistic, excessive analysis provided by the planning director and legal counsel. Those are attempts to persuade by minuscule interpretation of other parts of the code and an attempt to get away from the above easy analysis. The planning department is not responding to a ministerial directive. And you'll notice if you go through that, they use the word ministerial, which is where the direction is specific. This is attempting to change policy, which it cannot. Further, do not let the mountains of legal writing and legal arguing place you in a position where you say to yourself, I'm not a lawyer, and therefore must rely on our city attorney's argument. You do not. This is a de novo hearing, meaning you have the right to determine for yourselves what the evidence shows and what is most just and fair, considering history, plain language, and impact. This is not a metropolis. It is a small town, and the size alone gives you direction. The Meadows billboards have been here for years, and the company has conducted its business in a professional manner, complementing the area and been an important economic generator. They have the right to depend upon years and years of interpretation and application of signed codes by the planning department and thus the city. As mayor from 2013 to 2019, I am not aware of any confusion about the application of this code. Finally, to return to the language in question, 8 per mile with no more than 5 on one side of the street can only be understood by reference to the terms used. One side of the street absolutely modifies 8 per mile. The word with, by definition, means possessing as a feature or accompaniment. The 8 per mile thus contains the component of no more than 5 on one side of the street, and thus, by its very inclusion, applies and I'm going to use the word linear because until today, a lot of the stuff in the material kept using linear, and I'm a little surprised that now we're starting to use road where linear has been argued in the past. Please reverse the Planning Commission's erroneous decision. Thank you.
Any questions for Mr. Lawrence?
All right.
Thank you.
Hello, my name is Scott Hagee. My address is 6580 Martin Road, The Dalles, Oregon. Councilors and Honorable Mayor, appreciate the opportunity to be here. Understand the opportunity you have to make a decision, and it is your decision. First, I want to tell you that this issue has been kind of troubling me for a while, and I'm really been wondering why we as a community are really challenging a business in our community. This is a community that has operated, I would define them as one of the more philanthropic and giving businesses in our community. I think it would be hard to find a corporation that has been more willing to support and contribute to this community than Meadow Outdoor and its leader, Chris Zukin. And I'm pretty sure all of you would agree with that. But I'm not suggesting they get a pass for this. They don't get a pass because they're nice or they do good things for the community. No one is asking for a pass here. They are looking to continue operation as they have with decades and decades, and with the support of the city all the way along. That's all they're asking for. This issue appears to be one of interpretation. As humans, there are lots of things we need to figure out and interpret, often on a daily basis. In this case, this interpretation leads to a fairly significant change in your policy.
as leaders of the community, you need to be careful to not let an interpretation of staff lead to a policy change for the entire city. Perhaps there is an interest in policy change, but that change is clearly in your hands and not in your staff's hands. As someone who has worked most of their career in this community, working to expand and attract businesses to the city and the county, Meadow Outdoor is an exceptional example of a corporate citizen. We need more of them, not less. And I can tell you it's challenging to get businesses. The goal is to expand them and keep them here. And this is exactly what we want and what we've seen out of Meadow Outdoor. I'll leave you with some questions. What has changed? Why has the interpretation changed now? And is this business somehow creating some negative aspect to the city of the Dalles? It's not clear to me that what this might be, what this negative change is all of a sudden, and why this interpretation changes. If that is the case, if there is no negative change, then your decision should be to support this appeal and allow one of the great businesses of our community to continue doing the great things that they do. Thank you for your time.
Any questions for Mr. Hagee? Thank you, sir.
Last speaker. Oh, Charlie, second to the last speaker.
Hi, Jim Wilcox, 416 West 7th. And Chris asked me to be nice. If my being direct is interpreted as not being nice, tough noogies. Right? That's the way I am. It comes down, you got a pound of paper, which to me, if I were sitting there when I served six years on council, 2.5 years as mayor. If I got something that big, it stunk. It started to smell bad. What are they hiding? And more words you get, the more you can't read. And that's the way I always looked at the real thick staff reports. If you got a 2-page staff report, you can figure it out, have a discussion, get her done. That kind of staff report is what creates this. A measurement issue, and Mr. Dro hit it right on the head. Your staff is looking at one part of one sentence. And I'm sorry, Jonathan, but you can't put a comma where there's no comma. You read the sentence, and as I think Mayor Lawrence said, it's simple. I'm pretty stupid. I could figure that one out. It has nothing to do with radiuses. It's a line, and it talks about the street. It follows the street. And the argument that you can't measure if it's not straight, tell that to ODOT or the GPS they talk about. And I do know from experience that GPS can be wrong. Depends on where your satellite's at when it takes the pictures to where the line shows up. So that's kind of an interesting thing. And to say this is not a policy issue, come on, 49 years, 5 decades, 2 centuries, at least 5 planning directors have all been interpreting it this way. The new guy comes in, they're all wrong. Where does that come from? Now, if you back staff on this, you have just abrogated your duty to set policy, because this would be a policy change. Policy is made, maybe not this way, but through how this has been interpreted through the years. That becomes the policy. And this business of, well, once you find it, it's okay to change it and you don't have to go through council. I'm sorry, I don't buy that. If you buy it, you probably shouldn't be elected again. This is not Salem. This is not Washington, D.C. This is the Dalles, where you have control. Now, if you want to give away control, don't support the appeal, because that's what you will be doing if you support staff on this one. Now, I do have to say, Dan Duro and I went round and round on a lot of things, very similar to this, when I was on city council. And I want to put it on record. I 100% support Dan Duro and his position on this issue. Now, that doesn't happen very often. I think that tells you how crazy it is that Dan and I would be so strongly in favor of the applicant, or the appellant in this case. So with that, do your job, keep control, and wonder why so much staff time, so much paper was spent putting together something that is one sentence. Read the whole thing and you got it. Probably don't have any questions, but.
Well, I have maybe not a question, but I'm going to take strong exception to the implication that our staff stacked a 600-page packet to hide evidence and to mislead the council. I take vehement exception to that remark. And I will also say that when I was a city manager for 28 years and a mayor for 5 years, cities got in trouble much more likely to when evidence was not presented than there was too much evidence presented. I'll just leave it at that. Is there any questions?
This case, so it got into the weeds on.
Well, the
things not
weeds
in
were
the right zones and
necessary.
all that.
The weeds were necessary if we end up in court. And we've been to Luba once since I've been mayor, and it wasn't a good experience. So any questions for Mr. Wilcox? Thank you, sir.
Last week.
Good evening. My name is Charlie Foote. I reside at 919 East 18th Street here in the Dalles. I'm a local real estate agent and business owner. I've had a billboard in the Dalles with Meadow Outdoor since August of 2017. During that time, I've seen my real estate business grow dramatically, which I believe my billboard played a large role in. I've retained my billboard space for over 6 years because it has been such a great asset to the growth of my business, and I have no plans of letting it go anytime soon. I believe many other businesses also rely on billboards as there are many other long-term leasees. The billboards are often used to advertise local events and charities, which is vital to our community. I would like to add that Meadow Outdoor Advertising is one of the best companies I have had the pleasure of doing business with, and I think the full room here this evening is a testament that many feel the same way on a professional and personal level. Thank you for your time.
Thank you. Oh, any questions for Mr. Foote?
I have a question.
Whoa.
Sit yourself down. So you're directly responding to a comment made by the planning director about there's no economic part to this case that was listed in the document somewhere, but there is an economic. Is that what you're saying? There is an economic basis, not only to Meadow Outdoor Advertising, but to all the people that use the service, people who do the building and so forth, put the signs up, the employees. Is that correct?
Speak for myself personally.
Yep.
That is why I've continued to retain the billboard, and it would make sense that that's why other people do on a consistent basis.
So it has an economic value in your opinion?
Yes, for sure.
So thank you.
Mr. Mayor, if I may, Mr. Chandler, would you like to clarify how criteria is applied in a decision like this, just on that point?
I would, yeah. To the point that the economic impact of billboards is not a criterion that we use to review the sign code. So I think that'll keep it short.
Distinction between economic impact that may or may not exist and what you apply when you're reviewing a sign permit.
Correct. Yeah, we do not look at economic impact when we review sign permits.
Thank you.
Mr. Zukin, did you want to say something?
Yes, please.
Sure.
Chris Zukin. It's for clarification. Councilor Randall asked about the measurement being linear, radial. As I understand it, measurement is radial with the subject billboard at the middle and then a radial mile around that billboard, which is a 2-mile diameter circle around the billboard. In question, is that the measurement that you're currently interpreting the code to mean? Yes. Thank you.
Did you want to offer any more?
Just that is a.
No, I mean.
No, we're good.
Okay. I had some questions about the legal opinion from Mr. Ty Wyman that's dated September 5th. Oh, okay. Does anybody have a problem with?
No, I have no problem.
Sorry, Mr. Mayor, which I submitted a couple.
Okay, this is dated September 5th, 2023 to the Dalles Plan Commission.
Not certain it's on.
You may proceed.
Yes.
Okay, page 74 of the 600-page packet that we're.
So just to be clear, I do not have
I have the 600-page packet, but we did not reproduce it from
Okay,
the
do you have-
cities. We created our
you-
own.
you
I
have
do
ex-
have my memorandum.
You have access to attachment 10.
Exhibit 10.
Now you do.
No, I know I have that, but you're asking about an exhibit to the memorandum.
Exhibit 10. You're,
Okay, that's the memorandum. I have it.
you have that.
I do.
Okay, I'm go to the second paragraph, which starts with Meadow applied earlier.
Yes.
Okay. The reference appeal stems from planning staff's denial of a decision that would change the prior interpretation of the code to limit placement of billboards to 8 per radial mile, as opposed to the prior interpretation of 8 per linear mile. And then the following paragraph, there's a sentence that reads, if the text is ambiguous, then the municipality must look to the context of how the regulation was adopted and has been applied. So reading that, is your position that past practice over 30 or 50 years, whatever, is an appropriate criteria?
Yes, absolutely. Absolutely. We look at case precedents. The law relies upon not just the law that is adopted by any given body in its legislative capacity, but also how the law is applied case after case. And I believe Councilor Long's question went to that point. How was this language applied in a routine manner over the years? And we presented a lot of testimony from two people who've been here in the community applying this language for 30 years as to how it was applied. It's not necessarily going to be written out for every permit. We don't want a 10-page decision for every permit.
Okay, page 76. Third paragraph. This goes to the issue of economic development. The last sentence is, I understand the commission can expect to take substantial testimony at the hearing as to the positive effects that billboards have on the local economy. Other than Mr. Foote here, I haven't heard really any evidence. Maybe you could elaborate on how you feel. Well, I don't think we need to hear about whether billboards contribute to the local economy. I'd like to hear whether or not you think that is an appropriate criteria for making this decision.
Yeah, I drew the relevance to the economics of billboards from context. State law requires that the city, even the city council, read each provision of its land use code in the context of its comprehensive plan. That is why I drew upon the relevance of comprehensive plan provisions. Some of which address, of course, the economy of the city. I will state, to clarify, there's absolutely no need to get there. There's absolutely no need to go past the sentence that has been read and reread here. And to that point, we had a linguist, a professional linguist, give his interpretation of the sentence. And he said, clearly, it refers to what we were then calling linear mile. That's back when the distinction was linear versus radial. But Your Honor, that's the reason I brought up the economics of it. I do believe it's relevant. I understand Mr. Crane may not. And you know what? If you find two lawyers, you're going to get, no surprise,
Let's hear
two
from the
different
other
opinions.
Yes, thank you, Mr. Mayor. In general, his statement is correct that a comprehensive plan can provide context for a code provision, but only when when a code provision can be interpreted or read to implement a particular code provision. Broad aspirational statements, for example, I didn't scroll down. I guess the comp plan language is in an attachment to this attachment. But broad aspirational statements about supporting the economic development of the overall community is such a broad statement that everything in your code implements it, which means then, of course, nothing directly implements it, but everything generally. So broad general aspirational statements don't provide specific context for any particular code provision.
Okay, so we have a disagreement here. Right. Yeah.
Yeah.
Okay. Page 76. Let's see. Okay, it's the paragraph about 3/4 of the way down. A third contextual clue.
Yes, sir.
Okay. I understand there is no disagreement that the city has for decades applied the code to limit billboards to 8 per linear mile. Staff simply considers that interpretation to have been wrong. Mr. Chandler, does that summarize your position?
No, on the basis of, well, this, we're throwing around this term again. Not claiming that staff's interpretation is wrong, just claiming that they do not have enough information to show that this is how it's been done.
Any response to that?
Well, recognize that I wrote this before the first hearing. So there's been the conversation here, as it were, has evolved. I believe, however, as I heard the weight of the testimony that you just heard, again, from folks who were dealing across the counter with each other for years, is that there was no prior disagreement as to how that code provision was applied. And that remains my understanding. I understand that staff disagrees.
Okay, another disagreement. The following paragraph, I recognize the planning director's authority. Do you see that paragraph?
Yes, sir.
However, fundamental fairness suggests that no one may recant a prior decision once someone has relied on it. I really think this is a very fundamental question, and that is that you are suggesting that if the fairness should be a criteria for this land use decision.
Yeah, and my reference there is to case law, and I want to tell you at 8:16 p.m. I am really hesitant to start getting into and discussing case law right now, but the cases, I appreciate your question. The cases at Luba limit, and this has really come on over the last 10 years of our practice in the land use bar, have come on to limit what is called collateral attack on a previous decision. So if you make a subsequent decision, and my assertion here is and remains that to deny the present permit is to call the present permit application is to call the initial issued permit dating to 2003 is to attack the correctness of that decision, which would, in my mind, constitute an unlawful collateral attack.
Yes, Mayor Mays, thank you for that. I want to be absolutely clear on this point. It is absolutely critical to understand. This is not an application to replace an existing sign. This is an application for a new, larger sign at approximately the location of an existing sign. Nobody is attacking the permit for the existing sign. That sign can stay there till the cows come home, for all we care. You can replace everything on it, keep operating that sign till the end of time. Nobody's attacking a permit for an existing sign. What staff has done is denied an application for a new, larger sign at almost the same location, but it's an application for a new sign, and every application for a new structure or land use is reviewed according to the code criteria. Nobody's attacking, collaterally or otherwise, an existing permit or an existing sign. So that's what his memo goes on to say. The courts have applied these principles to prohibit Oregon municipalities from recanting the legality of permits previously issued. Nobody is recanting or attacking the legality of a permit previously issued. The permit for the existing sign is completely legitimate and valid and remains in force and effect. What we are denying is an application for a new sign.
Okay, let me put it this way. If the city council thinks that it is not fair that our planning staff has for 30 or 50 years interpreted the road mile criteria, and is that to me is a fairness issue. And are you saying that that should not apply because it's a land use is treated differently than say another kind of permit or?
Yeah, thank you, Mr. Mayor. I'm not going to wade into the question of to what extent fairness should enter your mind as you're making your decision. The question at the end of the day, from a legal perspective, is what is the correct interpretation of that code provision? If you come down on one side, then staff has been doing it correctly forever. If you come down on the other side, then we have to correct the way we've been doing things and do things differently. The Planning Commission agreed with staff and said, yeah, we look at the language of this code provision and agree with you. That's how it should be properly interpreted, regardless of what happened before with any other permit or permittee. It's up to you to make your own decision, what you think the code requires, the language of the code, the text and context. And if you agree with staff, then that's one decision. If you disagree with staff, that's a different decision. At the end of the day, we will do whatever this council decides the code requires. The other thing I don't want to forget, though, is yes, it's a mess. And please, at the end of the day, understand that direction to engage the community in an effort to revise the sign code is, I think, a high priority for everyone.
Yes.
Because that frankly, the language may not get you to where you want to go, but you're stuck with the language, right? So language is kind of a set of handcuffs. You're stuck with it, whether you like it or not. I think even Mr. Wyman would agree with that you can't just ignore the language of your code, but where it's open for interpretation, the courts will defer to your interpretation, regardless of what we've been doing for years or not doing for years.
Well, it's just that throughout Mr. Wyman's legal opinion here, the fairness issue seems to be raised over and over again. So in the interest of time, I'm just going to skip down to the last paragraph of page 77. That's already been answered. Okay. Thank you very much. Any questions for Mr. Wyman?
No.
Okay.
Thank you so much.
Okay, where is that? Okay. It's now time for members of the audience to weigh in.
Did that, Mr. Mayor. The audience weighed in.
We had 7 people representing.
Mr. Mayor, I'm not so sure that any of those were proponents or if they were part of appellant's presentation. And so the last thing I personally remember you mentioning was at the very bottom of that page that you're looking at now, as far as the script goes. I don't believe you've asked for comments from or testimony from those in favor of the application.
No, I have not.
Right. And so I believe that would be the most appropriate place to pick up on the rest of this public hearing.
Okay. Anybody have a problem with that? Does anyone wish to testify in favor of the appeal? And when I call on you, please state your name and address for the record. And I want to repeat your time limit is 3 minutes. I would suggest also that if there's nothing wrong with you just getting up and saying, I agree with Meadow Outdoor arguments. I agree with the council. Please, if you can be brief, I would encourage you to be brief because of the time commitment here. If any member of the city council has a question for a proponent, please speak up. Otherwise, I'll just move on to the next person that raises their hand. Again, there's nothing wrong with stating that I support Meadow Outdoors appeal or I agree with the arguments set forth by the appellant's arguments, and then sit down. With that, anybody want to get up and testify for up to 3 minutes?
Mayor Mays, you're about to go past 8:30.
Which means?
Need to vote to extend your time.
Okay, we need a vote from the city council to extend our meeting past the 3-hour time limit, which is coming up in about 8 minutes. Do I hear a motion to extend the time limit?
I'll make a motion to extend.
I'll second it.
It's been moved by Council Runyon and seconded by Council Randall to extend the time limit. All those in favor, please say aye.
Aye.
Any opposed? Okay, I saw a hand raised. Ms. Wood. Please please come forward and speak into the microphone?
Thank you. Carolyn Wood, 1709 Liberty Way. I served on the council for 2 different times for a total of 13 years, and it started in about 90. I never remember any discussion of this ever coming to council. But I would like to just say I totally support Zukin to Meadow Outdoor Advertising's appeal. I've also served on the historic Columbia River Highway, and we had a lot of discussions about signs and where they should be and whether they shouldn't be. I think we also need to remember that Lady Bird Johnson had a huge campaign to clean up signage along highways in the United States. And part of our sign ordinance in the state, I believe, and I don't know this factually because I have only been an observer and somewhat on the sidelines, to limit signs in Oregon to the regions close to cities. And I can't give you the exact mileage, but I know that there was a plan, and that influenced the sign ordinances within the city. And this would have been in the probably early 70s, because they were in office in late 60s, I think. The other thing I would like to say is, in our business, Hudson Insurance, for 42 years, we had billboards. And I also like to say that sometimes they were removed, and that was because the owner of the property decided they didn't want to sign there anymore. We had 2 in town, one across from Chamber of Commerce and the other one on the north side of St. Paul's Episcopal Church. And both of those we were on for several years, but anyway, those were removed. So anyway, I just say I want to support. I think this has all gone very well. I appreciate your time. I understand. I've sat there for many years. So appreciate your participation, and thank you.
Thank you. Yes, sir. Once again, if a counselor has a question for one of the proponents, please just speak up.
Thank you, Mr. Mayor and Council, and I appreciate you extending the meeting. My name is Dan Meter. I'm 911 East 7th Street. I'm a lifelong resident of the Dalles, and I'm also a land use planning consultant with over 50 years experience with Tennyson Engineering, and I'm sort of retired now. I've worked all over Eastern Oregon. I've worked for 30, 40 cities and more counties than I want to count. And I just want to say, I've also worked for the city of the Dalles. I acted as planning director before Dan Duro came on board. And that's a story unto itself. But in all those jurisdictions, I have never seen a sign ordinance just being proposed here tonight that uses that radial situation. It's always been a road or lineal distance. Thank you.
Thank you. Ms. Elsmore.
Ellen Elsmore, 110 East 9th, the Dalles. I'm a Honnold. We had the signs before Zukins. I want to back whatever Mount Hood Meadows needs. I totally back. And I think they're in the right. That's my opinion. Thank you.
Thank you. Anybody else? Mr. Ray.
Ethan Ray, 1804 Trey Heights. I support Meadow Outdoor Advertising, and as I travel around not only our community but out of state, I use billboards to help look for places to go. And I would hope that their generosity to our community would not be sent away. Thank you.
Thank you. Anybody else? Yes, ma'am.
Good evening. My name is Patty Blagg. I live at 814 East 10th Street. I'm a small business owner here in the Dalles locally. I'm also a volunteer and a board member in a number of nonprofit organizations here in the Dalles. And I just want to personally say that I definitely support Meadow Advertising. I have used some of his billboards, not only in business, but also as far as the nonprofit, which he does not charge for, to support a lot of our fundraising events for the nonprofits. So I definitely am in support of Meadow Advertising. Thank you.
Thank you. Anybody else? Any more proponents? Last call. Okay. We'll now move to opponents of the appeal. Does anyone wish to testify in opposition to the appeal? Last call. Okay, nobody wants to testify in opposition. Does anybody wish to testify? Does anyone wish to testify that are not in favor or opposition that would like to ask questions? Please state your name and address for the record if you would like to come forward and do that. Anybody? Seeing and hearing no one, we'll move on. Do we need this? No. Okay. Okay, does the city council feel ready to go into deliberations, which would mean closing the public hearing?
I do.
In favor.
Okay. Okay, with that, the public hearing is now closed. And we will now have council deliberations. Thank you for your brevity, everybody. Councilor Runyon.
I'd like to thank you for the list of questions that you had. It took the words out of most of our mouths, and it was very, very succinct and very good, very professional. There was a comment about GPS and how wonderful it is and all that, and I use it every day. But as former Mayor Wilcox pointed out, there can be issues, and one of those is how you program it for the result you would like to have. And programming it in this case for a radial map of a mile in any direction, yeah, you're going to get the answer you want, that there are too many signs. But the fact is, if you programmed it for the street, as it's indicated at least 13 times in the first 76 pages, to the center line of a street and down that street, whether it goes to the next curve or the other way, you get an entirely different amount, and there aren't too many signs. But the big issue for me is that this has been simple, as ex-Mayor Steve Lawrence talked about. And the points I made at the very beginning in my opening statement, I was thankful that they were readdressed throughout this, that it was very simple. And I read and I went back through and I just kept highlighting to the center line of the street. And that's where I'm at. If we want to do a policy change, it's got to be handled entirely different, which I noted as well. It can't come here in the middle of a case. It's going to have to come here separately, and we would review it, discuss it over a period of time, and then take a vote on it over months, probably. That's not the case here. This is an appeal of a decision, which, by the way, was not unanimous. I believe in supporting the majority, but the Planning Commission notes that I saw said it was 4-2. Is that correct? Right. Okay. So it wasn't unanimous, and people might have thought maybe it was, and it was not. And as the rogue on this council quite often, I appreciate those people that have dissenting views. As a former planning commissioner too, and in this body here, I totally agree that our decision is our decision. We are in charge. And what's best for the community is where I'm at. And if the rule needs to be changed, that's something for another day. Today, I'm supporting this business in their appeal. I just want people to know that.
Thank you, Mr. Councilor Runyon. Anybody else like to speak next?
The only thing I'd like to add to your comments, Councilor Runyon, is that it was a 4-2 decision, but I read a letter from John Grant today, who was on the commission that was absent that he said that he would have been in favor. So it would have been 4-3. So it's a tighter ruling than what we were led to believe. So I just wanted to make that comment. I believe that the intent of the 1992 request to address the road mile in the ordinance, I have a problem with the fact that it was not, when there was a request to add the verbiage, it was either ignored or it was not acted upon. And I have a major concern about that because that would have alleviated all of this, the problem that we're facing tonight in making the decision. I'm concerned with the overall positive or negative outcome of our decision, in that, you know, we look for the livability, the safety, the health of our community first. And how would this decision, how would it affect any one of those three aspects? That's a leading, this is beyond looking at the details. This is looking at a wider picture for the interest of our community. And that is a major concern for me as well. Plus the potential loss of economic loss, that it's not, that was not really clear, but I just feel that it just doesn't feel just or fair to change midstream after you've been, you know, something is established and you change the rules. I go back to when we were debating about the marijuana issue, where time, place, manner, right? And that was the same decision, is whether or not it was determined by radial or by linear, not linear, it was by road. So in that application, if I remember correctly, that was by road mile, because it would have affected already established retail outlets that were, you know, in dispute, and it would have affected that. So the city at that time set precedence in establishing that we did look at the road mile as a criteria for making that decision. Okay, that's my comments.
Thank you. Counselor Long.
So I do support the appeal, especially strictly, well, not especially. So if I'm only looking strictly at this, then I would say that it has been interpreted correctly, and I don't see a reason for us to have staff change how they're interpreting the current side ordinance. And if we want to do something, we should do it separately, specifically around that language. But all other things aside, which doesn't have a bearing on the decision, but I do support our businesses and Meadow Outdoor, and I don't see a reason that we would punish any business in town the way that this has come about.
Counselor Randall or Richardson?
I have a few comments. I want to address the fact that we had quite a number of letters. I lost track, dozens of letters, a number of form letters, but also some written thoughtfully. And it might be worth pointing out or putting some people's mind at ease that the decision tonight either way does not determine the fate of all billboards in the Dalles, nor does it determine the fate of Meadows Advertising. It's a large company, and the 42 billboards are 6 or 7% of the total portfolio in the Northwest, if I understand. So I do hope that those folks that might have felt this was an existential question could maybe be put at peace a little bit with that. I have another contextual comment, and that is, I'm younger than most of the folks commenting tonight. I'm older than most of the staff, so I feel like I may be appropriately situated to observe
Be careful.
most of the staff.
Counselor McLaughlin, you're out of order.
Thank you.
All right, I'll leave.
I feel that generational respect goes both ways. And I've heard or read a few comments to the effect, well, essentially, who are these new guys to tell us that we're doing it wrong or we're going to change things? Our staff in the 4 or 5 years I've been involved with city affairs have been very professional and have served us very well. And part of their job is to bring fresh perspective, or at least a very careful look at things. And we are regularly reviewing ordinances, going back and stress testing or changing them. And as recently as last council meeting, where our staff told us that city council had done some things wrong, and we had to kind of swallow our pride and change some things. So I do think that is appropriate. I want to make that really clear that that's of real value to us. I have a little bit of a question on the terminology of policy. I've heard what I consider really convincing testimony tonight that there's been a consistent process of, I guess, Mr. Duro used the term art in terms of interpreting code and over the previous many years. I don't know if that was actually policy so much as interpretation and the accepted way of doing things. And if so, if that was an interpretation more than a precise policy as outlined in various bits of code, which is what it seemed like, then it behooves us to clarify policy, as other people have said tonight. So I guess what I'm getting at is I feel like we're a little bit on the point of one side saying, this is the way we've done it. And there's a lot of value in respecting consistency. And then having heard some argument that maybe that's not strictly correct if we look at the code in total. So it's kind of a tricky balance to come down on the one side or the other. We're told we're not supposed to make policy with this decision, or we're not supposed to consider policy implications. So I'm trying to keep that in mind. I would say perhaps after the public hearing, I would like my fellow councilors and I to be able to give staff direction on bringing back a set of sign code revisions or suggested revisions, and start that conversation in a more sort of holistic and thoughtful manner that goes beyond just one evening. And if the previous process was a process that was defined by professional judgment and professional interpretation, and our staff today has a new interpretation, and that calls into question that we need to really clarify that and not leave it up to staff. But it also may behoove us, I guess I'm trying to sort of cut the pie here a little bit. I wonder if it may behoove us to give a grace period for when things change abruptly, whether it's policy or interpretation. So I'm wondering if we can really commit to coming back within a set period, 6 months or a year, to review our and revise our sign codes. And also just to give, for lack of a better terms, Meadows a freebie, a pass on the abruptness of the change in interpretation, and support their appeal. Feels like two different questions, and I'd like to be able to answer both of those tonight: the appeal question and the staff direction question.
Would the city manager care to comment on at least the one suggestion?
Well, one comment I can make, and I think Mr. Chandler and Mr. Duro and other planning directors, is that when the code is ambiguous or there's some gray area, no one really prefers or likes that. And so reviewing the sign code, bringing that clarity is always helpful. When you have those gray areas or we have language that could be interpreted one way or another, that is the responsibility of staff and of the planning director to apply that interpretation. And then we have the process that we're going through this very evening to check that and bring that attention to the planning commission and then the city council. And so providing, direction to staff, as we've already indicated, we have some intention on looking throughout the sign code holistically to identify areas such as these to bring greater clarity and efficiency. I think would be very prudent. And I think it's an ongoing effort as well. As noted this evening, we've had various efforts over the decades to review and keep tightening up the sign code as well as other code that we have as we encounter these different situations, these different nuances. It's hard to predict, every scenario that you may come across. And so there's that balancing act there. And so we've had conversations prior to this. We talk about the city council goal setting process that we go through, the number of different initiatives that we have, and, undertaking a sign code review effort is certainly something that our planning department can undertake. There's always a balance between if everything is a priority, then nothing is and whatnot, and bandwidth with city staff. But, with that direction from council, it provides guidance for us going forward. I hope that answered your question. At least one of them.
I guess it's a question for the rest of the council, post public hearing, whether we are going to commit to giving you guidance and even an expected time frame for returning. Yeah. Would it be at all legal or proper in the course of this evening to put a pause on new billboard permits until such time as we get proposed code revisions?
I think that might be a whole nother question.
Whole nother question. It's just trying to wrap it all up in one ball there.
Councilor Randall.
Thank you, Mr. Mayor. I appreciate accuracy and precision, and that's the aspect of the staff's interpretation that appeals to me. However, I have high regard for honoring the text and history of the ordinance, as well as the expressed desires of the community. So I will support the appeal.
Okay. I just wanted to point out in the discussion about our sign ordinance and Mr. Cleaves's remarks is that I think Meadow Outdoor during the process of this, certainly in the 600-page packet, I've seen several references, and I want to quote, "This request in no way precludes future collaboration on legislative amendments to clarify the sign code." And I appreciate that attitude, and I'm looking forward to, based on how I see this vote going, that collaboration is going to be mutual, and we're looking forward to some real work done on the sign code. Okay. With that, we're looking for a motion, I believe.
I can make the motion.
Go ahead, Councilor Long.
So I'd like to move to adopt resolution number PC 618B-23, a resolution granting APL 35-23, reversing the Planning Commission's denial of APL 3323, and reversing the Community Development Director's denial of sign permit number 258923, based upon all evidence submitted and entered into the hearing record.
Second.
It's been moved by Councilor Long and seconded by Councilor Runyon to approve the resolution as described. Sorry.
Matthew's giving me a look. What is it?
I'm looking at the motion language here.
Yeah.
Council requirement to identify the criteria supporting its decision.
So
In the motion?
well, it's mindful. It's important to be mindful of the fact that our land use and development ordinance requires a resolution sort of affirming the council's decision here tonight. in the resolution, we need to include substantial evidence of some kind.
Well, the resolution would include the findings of approval, and Josh and I were just talking about that. He just needs to revise the findings for 13A, I think, and 15 to note that they comply with the criteria, and then
Right.
those would be attached to the resolution.
And so functionally, then it's revising finding number 15. Is that what it is?
13 and 15, right?
And just to say, criterion met.
Right. We'll do the 8 per road mile standard and cite to the evidence and demonstrate the criteria is met. I believe I heard from the city council tonight that that's how you interpret that code provision. And with that interpretation, the application does meet the criteria. So we can write that finding, attach it to the resolution, have the mayor sign it, assuming there is a vote to do that.
And Councillor Long's, what she said is suffice.
Yes, sir.
Yeah,
It
okay.
is.
That's the bottom line. Thank you.
Just to confirm, Councillor Long, because it was a very long motion, and I know that they are very long. Did you read the one from the updated memo that?
Yes, I did.
Perfect. Thank you so much.
Okay, there's been a motion and it's been seconded. I believe Councillor Long, seconded by Councillor Runyon. I'm going to ask for a roll call vote.
Yes, for discussion.
Is there any discussion? Councillor Runyon.
I would just like to reiterate, I appreciate the work the planning department has done as well. It's laborious, it's lengthy, nothing personal in a business decision. We're all here together.
Right.
We've had great people in that chair right there. I've argued with Mr. DeRoe a time or two at planning commission meetings years and years ago, and his assistant, Mr. Kyler. So that's just part of the deal, and that's all there is to it. So I do say you worked hard, did a good job.
Thank you. And I agree with that.
And you're referring to the remarks that were made by Councillor Richardson. Is that right, Councillor Runyon?
I can't always hear him. I don't know why that is.
Needs to get closer to the mic.
I'd also like to echo those remarks. Fine job. Okay. Any more discussion?
No,
Roll call vote, please.
Counselor McLaughlin,
I'm in favor of the appeal.
Counselor Long, Counselor Randall,
Aye.
Counselor Richardson.
Aye.
Counselor Runyon.
Aye.
I guess I should come back and say aye.
Thank you.
Okay, you're all welcome to stick around and listen about our purchase of a parking lot and a moratorium on short-term rentals. But assuming that most of you are not interested, we're going to take a 5-minute recess and allow everyone to clear the room. Thank you all for coming. 5 minutes. Okay, item 11A is the downtown real property acquisition. Mr. Klebs.
Thank you, Mr. Mayor. I want to make a joke. Does everybody want to buy a parking lot and a staff report? But I will go into a little bit more detail. You have my staff report in front of you. The Dalles is preparing for significant acquisition and redevelopment of several properties in the downtown core, including the former Dalles Chronicle building into a grocery store with a few other businesses inside. The acquisition of the Gobi building on 3rd Street right next to this grocery store by Wasco County for administrative offices. Next to this, again, moving to the east, there's a proposed, and as the council knows, a multi-story mixed-use residential development of 108 housing units. And not too far away, we have the redevelopment of the Tony site. These are all tremendously exciting downtown revitalization projects that will bring new businesses and new employees and new residents to our downtown who will patron those businesses. And so looking to those needs and those developments, we have this proposal tonight to acquire 2 parcels for the development of a parking lot. While the current data that we have shows an adequate supply of on-street free parking, and most of these developments will have some degree of off-street parking, nevertheless, we want to make sure that we are looking long-term and the continued growth and revitalization that these developments will hopefully spark. We're looking to acquire these properties that are on 3rd Street immediately to the east of Sawyers. And so those are the 2 parcels at the corner of Laughlin and 3rd Street. It's one of the old car dealerships with the kind of vintage sign along the perimeter, as well as the immediate adjacent parcel, which is about 3.5 or so feet higher. So they're kind of offset. The two parcels are kind of offset. Including in your packet is a rendering that would show what a new parking lot would look like once we leveled these two lots. And we'd be creating approximately 23 public parking spaces with 1 ADA space. In many ways, this parking lot will look and mirror exactly like the Arco parking lot that's across the street from St. Peter's. It's a very similar type of development. One of the considerations here, mentioning the Arco parking lot, is that we do, looking at the downtown from a bird's eye view, on the west end of the downtown, you have the Arco parking lot, which provides public parking. Kind of north central to the downtown, you have the parking lots along First Street, which provide parking in the center of downtown. And then currently on the east end of downtown, on the other side of the roundabout, we have a parking lot as well. But it's most often used as a park and ride facility. It's a little separated or disconnected from the downtown proper itself because it's on the other side of the roundabout, which is not the easiest thing to cross as a pedestrian. And so this parking, the acquisition of these lots and the creation of this new parking lot would better fit and fulfill the need for that east side public parking, immediately adjacent to many of these different developments or within a few blocks, as well as that east end of the downtown. These parcels were bought by the current owner earlier this year in May 2023. Each parcel, the larger parcel closer to Laughlin Street was $350,000, and the smaller parcel was $105,000 for a total of $455,000. We've negotiated a purchase price for these two parcels of $484,163.79, which is overall a general modest increase in the purchase price just from earlier this year, taking into account some of the closing costs associated with that. We do have access to a phase 1 environmental study that was done in May of 2023. So again, just earlier this year, we will have to do some asbestos and lead testing on the structure that is there prior to demolition in preparation for the development of these parking lots. For the development itself, and the numbers are really close. So the purchase price, like I said, is $484 and change. The development costs are $485. So it's just happened to be with the cost projections that we have, very, very close numbers. That would be the cost to develop these parking lots, $485,151.02. This is utilizing some in-house labor and resources from the Public Works Department that we would pay for, but uses some of that in-house city staff to accomplish a few of the different elements of the parking lot development. This estimate also includes landscaping along the frontage of 3rd Street as well as Laughlin Street, but does not include costs associated with the actual sign on the property itself. We have some continued discussion about what we could potentially do with that sign. Could we reclaim it somehow? Could we use it in another way? And so that would be part of staff's work and diligence if we received approval on this acquisition tonight. One of the other important considerations here is that we have engaged the Urban Renewal Agency to partner with the city in the development of these parking lot, in particular because it aligns with a specific goal that the agency has, Goal F, which is to provide an adequate amount of properly located and designated off-street parking, including disabled parking in the downtown area. And so we've approached and have gotten preliminary support from the agency that we would approach this project, both its acquisition and development, in essence, as 50-50 partners. And so if we receive approval tonight to purchase these lots, we'd also be looking for approval from the city council to bring a proposed intergovernmental development agreement to the agency at its meeting in December of this year, if possible. One of the last points I wanted to mention here is that these lots currently are privately owned, and so they do pay a certain amount of tax. And so as the city acquires these lots will come off the tax rolls. Looking at the county assessor's files, these two parcels combined in 2023 paid just under $3,900 in tax. So that is one component here I want to make sure the council was aware of, as it's often brought up in discussions. I think this small amount, relatively small amount of tax revenue will hopefully be offset by the development and redevelopment that this new parking lot will support. As I mentioned previously, the redevelopment of the Griffith Building into 108 unit housing development will dramatically increase the tax rolls, as will the redevelopment of the Tony's lot. Some of the budget implications that we have here, the acquisition, as I mentioned, was 484,163 and change. And staff is proposing that we utilize some of the remaining ARPA dollars that we have for this acquisition. And then per the proposed intergovernmental development agreement, the acquisition and development cost would be split. The difference between the two is approximately $500. So we would use ARPA dollars for the acquisition and then contribute 500 additional ARPA dollars to the development costs, and the Urban Renewal Agency would cover the rest in essence. So again, in my staff report, I kind of provide a summary of the acquisition and development costs for your reference, if you have any questions. And so with that, our recommendation is to adopt special ordinance number 23-599, special ordinance accepting the dedication of real property on East 3rd Street, Jefferson and Madison by title only, and authorize the city manager to execute a development with the Columbia Gateway Development Agreement with the Columbia Gateway Urban Renewal Agency, contingent upon the agency board's approval. Again, as I mentioned, ideally at the December meeting. And I breezed through that pretty quick, but I'd be happy to answer any questions that you have or go back and review any segment of my agenda staff report.
Any questions for Mr. Klebs or any for the staff? Council Runyon.
Well, I will vote for this, but in earlier conversations, we talked about this. I'm not really in favor of the parking lot aspect. As long as we don't build structures on it, I'm pretty good with it. Because I look at this as a piece of control for future development in the city. If something came along that could really benefit the community, we would have some land that we could direct them to. So that's a possibility as well as just a place to park cars by having control over a piece of property. Not having that control when we have the opportunity leaves it open to whatever. If the code says it's okay, they could put a adult shop there or whatever else they wanted to do.
Bill, let's be careful there.
Maybe a bad example for Rich.
What?
But anyway, so I'll support it, but I'm still in the back of my mind thinking somewhere down the road, as we look to the future, this might be a piece of property that we could direct. Maybe it's a city office to, or some other agency, or some other retail, business that we might be beneficial to the community, and we'd have the ground for it. So
I think
I just want to keep that in the minutes and the thoughts that was a discussion at this point.
I think your comment hits upon several different opportunities. One is to the opportunity that we have to acquire these parcels now before these various developments go in, which would raise the value of this property conceivably down the road. The second opportunity is that we would be in control of this parking lot and so can proactively manage it to make sure it reaches its maximum utility as best as possible, balancing customers, employees, and residents. And then the third, most notably, as you hit upon, is that this parcel will have value down the road. And we may want to keep it as parking for a very long time because that's what we've determined its highest and best use is. But we can also dispose of that property and sell it down the road if there's a proposal that comes along or someone wants to use it for a different use. So there's kind of a mixed three different opportunities that come to mind based on that comment.
You see this as a parking lot that is open and available to the public for free parking, first come, first serve, or are you thinking about a pay per space parking lot?
My perception is that this would be a free parking lot, similar to what you see at across the street from St. Peter's. We may employ some of the mechanisms that we have similar to First Street. So if someone wanted to park in this parking lot overnight, we may require them to get a permit. And so that may be a great way to engage with nearby residential users of the lot who maybe need the parking lot overnight because they're staying in their apartment, but then they leave during the day for their place of work, freeing up that spot for employees and customers that come down. So I think long story short, my intention here is to have it as free parking like we do at our other parking lots, but there are a couple different strategies we can use to maximize its utility.
Thank you.
Counselor McLaughlin.
I support this action item with a contingency that emphasis be placed on preserving that sign. We don't want to see it torn down and just destroyed. We need to work at finding a home for that. Maybe with David Banco and maybe something of that nature.
I think there's a couple different opportunities we can have to potentially integrate the sign into the parking lot itself, or other opportunities such as with the National Neon Sign Museum. We're starting to grow a decent collection of signs with the 2 signs that came off the Tony's building too. So I think there's definitely some opportunity there.
Good.
Anybody else? I hope we get some really good landscaping on that parking lot. We picked the right trees. So, looking for a motion?
I can do that, Mayor Mays. I'll go ahead and move to adopt special ordinance number 23-599, a special ordinance accepting the dedication of real property on East 3rd Street between Jefferson and Madison Street by title only, and authorize the city manager to execute the development agreement with the Columbia Gateway Urban Renewal Agency contingent upon agency board approval.
Is there a second?
I'll second that.
Been moved by Counselor McLaughlin and seconded by Counselor Richardson to we got the
Read by
read by
title.
title, don't we? Does anybody want to
No.
does anybody want to have the ordinance written in or read in full?
No.
Okay, I'll take that as a unanimous feeling. Okay, it's been moved.
Want me to
I'm
read
sorry,
it?
go ahead. You
Okay.
got to read the title.
Special ordinance 23-599, a special ordinance accepting real property on East 3rd Street for public parking.
Okay, it's been moved and seconded to adopt this ordinance. Is there any more discussion? All those in favor, please say aye.
Aye.
Any opposed? Motion carries unanimously. Thank you very much. And finally, tonight we get to the short-term rentals and the concept of a moratorium. Mr. Chandler, are you taking this on?
Yeah, thank you. Thank you for your commitment this evening, your patience. I'll try to get through this one relatively quickly as well. So to recap, at our October 23rd, 2023 regular city council meeting, community development staff coordinated a discussion with y'all to look at the city's short-term rental license program and to reevaluate existing ordinance and address concerns that we've heard. Staff provided a brief history as well as highlighted some various topics that may later be used for future amendments. These topics included the consideration on the number of short-term rentals allowed in the city, overall operational standards, as well as a breakdown of short-term rental type classifications. This was the first staff-led council discussion since the ordinance had been adopted in 2020. Since the license program was first adopted in 2020, there has been a growth in the Dalles. We saw 35 permitted in 2021 or licensed in 2021, 56 in 2022, down slightly to 51 at our current inventory that we have. These numbers include not only these short-term rentals, but also bed and breakfast permits, which are the former land use permits that are slowly phasing out. And actually, we will see more and more of those phase out. Just in this year alone, 12 of those existing bed and breakfast phased out. So that's probably why we saw a slight dip in the drop of about 5. A map per Mayor Mays's request has been provided on page 597. This shows in red, all the dots in red are the short-term rentals spread across the city. As you can see, majority of these are located in residential zones. During the October 23rd meeting, staff discussed the differences between owner-occupied and non-owner-occupied short-term rentals and the potential impact in residential neighborhoods. Operators living on site have more opportunity to monitor the actions of their guests compared to non-owner occupied units. Non-owner occupied units function more like a business, and they lack typically lack on-site management, and that can pose potential impacts to the surrounding neighborhood and requirement for others to step in, whether it be the city or whether it be the neighborhood. Throughout the city's current housing needs analysis update, there have been numerous comments, concerns regarding the impact short-term rentals can have on housing availability and affordability. Currently, 34 of the 51 licensed and permitted short-term rentals within the city are non-owner occupied units. However, I do want to point out that 19 of those are operated by individuals that are living in the Columbia Gorge, and 11 of them are in the Dalles itself. So although they are non-owner occupied units, they aren't too far away. Just wanted to provide that insight. Over this past year, you've all heard numerous concerns regarding these operations. The concerns that we've heard are typically for short-term rentals operating in residential zones. So to best address these concerns and to allow some time for a more comprehensive review of the current short-term rental license, staff presented the option to place a moratorium on new short-term rentals. During that discussion, it was a consensus of the council to direct staff to prepare a moratorium for consideration. Council specifically requested that the moratorium be placed on new non-owner occupied short-term rentals located within residential zoning districts. This does allow for an operator to continue to, or a new operator to operate within a non-residential property, a commercial property, to obtain licensure, as well as to allow existing operators to continue to operate of those that are currently operating. So staff has prepared Resolution 23-039 for your consideration this evening. And it is to specifically, as it reads, city staff shall not issue any short-term rental licenses pursuant to the Dalles Municipal Code for any residentially zoned, non-owner occupied short-term rentals, provided, however, operators are in good standing. And some additional language is in there. The good standing is making sure that they are up on taxes, making sure that they have a valid license, make sure that it's not a code issue that we're chasing around some operator. And this would be in effect until November 26th, 2024, unless sooner repealed or modified by council. So with that, council's alternatives, staff's recommendation, move to adopt resolution 23-039, suspending the processing and issuance of short-term rental licenses under the Dalles Municipal Code, chapter 8.02. There are some other alternatives there for you, and I am more than happy to answer any questions.
Questions for Mr. Chandler?
Did you invite folks in who are currently in this occupation to speak to you about? Go ahead.
We did not. It would be trying to figure out who prospective hosts might be would be possibly difficult unless we reach out to some of the larger. I know there's a company in the area, Arrived. They manage many short-term rentals, but we did not reach out to anyone for this.
I want to hear what
Councilor
McLaughlin has.
question, when will this be enacted then? Is there a time period?
Upon adoption.
On adoption?
Yep.
And that means that an applicant that maybe received their license a week ago is not impacted. They're
Correct.
grandfathered in.
Correct.
Just want to make that clear. Okay, I'm fine.
It also applies to all new non-owner occupied short-term rentals within the residential zone.
Correct. Yes, very specific to that zoning.
That's great. Anybody else?
Well, one more comment that make sure that we have input from both sides of the argument, residents and owners, so that we go down the path. We give one voice, one vote kind of mentality. And I know you will do that, but I just want to say that. So we make sure that we emphasize that there's transparency and also we take input. Okay. I'm fine.
I appreciate the map. Very, very nicely done and very. It looks like, with the exception of around 3rd and 4th Street, where they come together, looks like the rest of them are pretty spread out. Do you know why there's at that particular corner? Is that there seems to be a bunch of them in that one corner of where 3rd and 4th come together? You understand? You see where I'm?
Yeah. I think it actually is only 3. They're rather large, irregular shaped lots. But yes, 3 properties that abut each other all have one.
They're large historic homes too.
Correct.
And so that's the draw, I think.
Okay. Okay. Anybody else? Anybody want to make a motion?
Well, I appreciate, this is a comment, neither question nor motion. Appreciate the staff for acting on our directives. And we give them sometimes a lot and they follow up. And I don't know, that's the way it works everywhere. So at any rate, thank you for that. And I will make a motion to adopt resolution number 23-039, suspending the processing and issuance of short-term rental licenses under the Dallas Municipal Code, Chapter 8.02.
I'll second it.
Been moved by Counselor Richardson and seconded by Counselor Randall to adopt the resolution suspending and processing and issuance of short-term rental licenses. Any more discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries unanimously. Thank you very much, Mr. Chandler.
Thank you.
And
Just one quick comment. Just one quick comment is my compliments to both Mr. Chandler and Mr. Cara on turning this around and maintaining a high degree of detail and professionalism through it. As you probably guessed, it was quite a bit on their plate over the last few weeks. So I wanted to thank you both.
I'd like to thank the two of you as well. Thank you.
Me too.
Any other business come before the council? With that,